number 9, my lord, annexure A is the notice, my lord. They have fixed the reserve price, my lord, 20 lakhs, my lord. In first paragraph, last but one line, my lord. The reserve price will be rupees 20 lakhs.
Please come. Then the presented petition is filed, questioning the auction notice. Then counsel for the petitioner submits that he has purchased the property in the year 2019, and he has obtained he has mortgaged the property in the year
19.
in the year 19. It is submitted that he has availed loan of rupees 32 lakhs. Now the amount outstanding is
38 lakh, my lord, 85,000.
38 lakh 85,000. It is submitted that the property of 40 lakhs in the year 2019 now is put to auction with a reserve price of 20 lakhs. Even after this property is sold, if still the petitioner has to pay the amount, the bank, only with an intention to cause loss to the petitioner, and for the best reasons known, the property is put to auction at 20,000 reserve price. Next para. Though this court is conscious of the fact that what are the parameters for this court to interfere in a surface proceedings where a sale notice was issued. This court has perused the sale deed dated 2009 sale deed of the year 2019, where he has purchased a property for an amount of rupees 40 lakhs. Now the reserve price is at 20 lakhs. Considering the same, the sale notice dated 29/9/2025, and where the sale is scheduled to be held on
Today, 29/10.
29
Time is also not fixed.
29/10/2025 is date till the next date of hearing. The petitioner shall take out hand summons on the respondent bank and shall file a memo to that effect by 10th of November, or else the stay granted by this court stands vacated. This is matter on 11th.
Achha.
Till number
Yes.
25. Vinod Prasad.
Here for the petition amendment. As per annexure E at page 20.
Yes, who appears for Bank of Baroda?
Bank of Baroda, Puran.
You appear? Mr. Vignesh Shetty is directed to take notice on behalf of the respondent. Any urgency in this matter?
Urgency is already they have taken order from police protection. Then
This is matter, get instructions.
Give me.
Get instructions, list this matter on 3rd of November.
Till number 26.
I number 1 of 25 is filed dismiss of the production of the original certified copy of annexure P and Q. Is dispensed with for the present. Yes.
26. Raman Swami BA. Morning.
For respondent bank, my lord. Morning, they told they will be
Why?
withdrawing the petitions.
Where are they?
They have not completed the interim order, my lords.
Hmm.
And prior to this, they have filed one more writ petition, wherein there also they have not completed the interim order, they have withdrawn the same. Prior to this, one more writ petition was there.
Hmm.
That also they have done the same thing. They didn't complete the interim order, they have withdrawn the same. And simultaneously, they approached DRT also.
No. They are not seeking any, liberty.
No.
So will.
Because that's matter sub judice, my lord. They already have filed essay there in DRT. Essay number 371/24.
The Land Council for the petitioner has filed a memo of withdrawal. Land Council for the respondent submits that they have obtained an interim order in this writ petition on 28/11/2024, where a conditional order was granted, directing the petitioner to deposit a sum of rupees 30 lakhs on or before 4/12/2024, and the sum of rupees 50 lakhs 4 weeks from thereafter, wherein which the interim order automatically stands vacated. It is submitted thereafter. They filed another writ petition.
Prior to this, after this, they have done to DRT, my lord.
It is submitted now. They have approached the
Essay 371.
DRT. It is submitted by the Land Council respondent. There is nothing but a pure abuse of process of law. as the petitioner has already approached this court and considering the memo that is filed, the writ petition is dismissed as withdrawn. Yes, next.
Number 27, Gopal KB.
It's an house property.
Yeah,
It is
Appearing
an
for the
house
respondent
property. I
bank.
borrowed a loan on 2020. 2020. At that time, there is a corona. I'm a farmer on. Then I borrowed the loan of the overdraft facilities. Due to the corona and other lapses, I'm not paid the in time.
How much is outstanding?
32 lakhs. my lord.
32 lakh rupees. Some amount, I'm the overdraft.
When is the auction?
No, this is the possession notice.
Possession
In fact,
notice.
last date, they were, council's colleague had come and said they will actually bring up some sort of a payment plan as to how much they would be agreed.
That's how it is adjourned.
Yes, yes. In fact, they'd approached the bank and, but then no payment.
10% of that amount, others, I will ready to pay about,
Should we do it with 10%?
because all the losses is going on, the interest is also
But
going.
that's not the job of this court under 226 in a surface proceeding. This court will
Allah-
only interfere
Allah-
provided you come up with a timeline when you are going to pay the amount. On that, I will dispose of the matter. This 10%,
Now-
5% will take it any, no, will not take it anywhere.
8 lakh rupees within week, Your Honor.
Then there
Then
are,
within the 6 months, we have entire amount is to be closed.
6 months is too long, my lord. 6
Allah,
months is too
this
long.
is a bank and the customer. We have also paid regularly, we have paid the overdraft facilities. Regularly, we have paid the interest also.
In fact,
Overdraft facilities
So,
itself,
what you do
itself
is-
is to
no,
be
no,
go
no.
for the.
what you do is you come up with an undertaking before this court saying that tomorrow or whatever 2 days, I'll pay 10 lakhs. Then after 1 month or 1.5 month, another half, another 1.5 month, another half. That's the timeline. If you are ready with that, I'll pass an order accordingly. Please get instructions from your client.
Kindly we will post it for tomorrow or day after
Not
tomorrow.
tomorrow, we'll have it on 4th. By the time you file the undertaking.
Then I find it. How much?
Yes.
It is overdraft facilities, you have paid the interest. What?
Here, the difficulty is, what is the power of this court under 226?
I'm disputing.
No, not you. That's a whole problem in all these matters. We can understand, we can only decide the legal questions that are there.
I mortgage the property. Is a secured loan.
Yes, yes,
nothing.
please come, please come with that. Then counsel for the petition submits that they are ready to pay the entire amount. They'll come before this court with an
Entire amount.
undertaking. They'll come before this court with an undertaking about the timeline when they are going to pay the money. Let's just matter on 4th of November.
great.
28, Porter, Girish Kumar. Vinay
In this matter, not some read by a senior advocate, my lords. Today, my lords, he has some throat infection. In fact, he was in the VC, my lords, for other matter, for making a request for
I
time.
only,
How many times this matter is?
Please, my lords, I understand that,
only
but in
one
fact,
thing I would
yesterday
like to
afternoon also,
bring
I briefed him in the High Court itself. Morning, he said that not, he has a throat infection. Therefore, he has not come to court today.
my lord, I would like to
But
make
if-
one submission, my lord. On the merits, I was addressing the arguments, but I would like to tell this court how they have been abusing the due process of law. They filed an essay 253 challenging the sale notice.
No, the
Alert.
senior, 1 minute, the senior counsel, I mean, the other matters also. Yesterday also, like, he's not well, completely is not in a position to argue. But I will, whatever
The
you see.
interim order may be vacated, my lord. Only question is, my lord, after,
No, having enjoyed the interim order from a long time, we'll have it on Monday, November 3rd.
I have sold the property also.
Yes.
25% is
No,
deposited. I
whatever
am
is
not
the
able to
abuse,
proceed in the matter because of this.
whatever is the abuse, we'll hear it and we'll pass orders. And I'm telling, if the senior counsel can't come on 3rd,
Please, my
you have to make your own
I'll make my
arrangements.
submission.
No business of Passover on Monday.
Please,
Yes, Monday.
I make.
Finally,
on
no further adjournments and no Passover will also be granted.
On Tuesday, my lords, may I request. Monday, my colleague's marriage, my lords.
Friday, let it be on Friday itself, my lord. But that-
Friday, it's not possible for the court, 4th November.
Very grateful.
Yes. Yes.
List number 3. Case number 1.
Huh?
My candidate.
In the earlier matter, interim order is extended till then, yes.
For the respondent.
What
my
about,
lords,
we will call it at 2:30 and dismiss it because it's already 1:35.
Please.
Yes.
Case number 2.
Orders
Order
matter.
matter, case number 2.
Can you permit me to convert this RPFC into the
Writ
writ petition?
The office, the RPFC is filed against an interlocutory order passed by the family court. And the office has raised objection with regard to maintainability. Land counsel for the petitioner submits that he may be permitted to convert this petition into a writ petition. The registry is directed to return all the papers to the petitioner, and the petitioner shall file the writ petition within a period of 1 week from the date of receipt of the copy of this order. The RPFC is disposed of for statistical purposes. Yes, next.
Cell number 3, hearing on IA.
Notice,
Cell number 4,
yes, 4, pass over, 5.
delay notice has to go.
No, but 13 days delay will hear. Yes, 5.
Cell number 5,
I am Lord, I represent the petitioner. 32 days delay.
What is the order?
Lord, maintenance order, my Lord. Granted in favor of divorced wife, Lord.
How much is granted?
Lord, 2,500 to the wife and petitioners, Lord, the children 2,000 each. Totally it comes to 7,500. Lord, his earning is just 400 rupees per day. Lord, and out of which, my Lord, he spends.
On condition of 5,000, because we can't reduce more than
There's
that.
a delay, my Lord.
Huh?
Delay is also there.
Notice will order. You don't want an interim order?
Interim order I want, my Lord.
The
Whatever,
present
my Lord,
petition,
please.
the present RPFC is filed, questioning an order passed by the tribe, by the family court, whereby an amount of 7,500 is awarded to the daughter, to the children and the mother, to the wife and children. Then counsel submits that his income is 400 per month and is not in a position to pay the said amount. Considering the same, there shall be stay of all further proceedings on the condition that he shall pay 5,000 by 5th of every succeeding month, and the arrears also at 5,000
Please.
within 8 weeks.
Great.
Notice to the respondent. Yes,
cell number
next,
6. Cell number 6,
you appear.
right,
So petitioner,
Yes.
there was a continuation of delay for 55 days, my lord.
That we do.
Yes, ma'am.
What about the main matter? We can dispose it of.
That's it. Final order has been passed, my lords. And lordship may kindly see page 140. There was an extramarital affair, my lords. There were 4 disputes that
We'll hear IA number 1025 is filed to condone the delay of 55 days in filing. Condone, admit post for final hearing.
cell number 7,
Great. sir.
Adi Narayanappa, notice has to go.
Notice to respondents. And 7,
Cell number 8,
8 days will hear.
15,000 minutes is awarded by the,
It will go. Once we know order notice, it will go. Yes.
15,000 is ordered by the, 15,000 is ordered by the family court.
What is your income?
Income, my lords, 80,000.
Huh?
In the, I have not, not produced
80,
the,
80.
I have not stated, I have not produced the affidavit, not sir.
But your income is 80,000. And then what is the
But
difference
my
between paying
grievance is
15?
not, initially they filed a MC petition. Lord, that was, my petition was dismissed and her petition was, or section 9 petition
Sir,
was.
it is right now for an interim order, 1 lakh is your income, 18,000 is granted.
Yes, sir.
So there can't be any difficulty for you to pay. Notice to
Madam-
respondent. Notice will see. Yes.
next for admission matter, cell number 9,
Notice,
cell number 10,
notice.
cell number 11,
Huh?
Serial number 10, my lord.
There is no stay petition.
Lord, I have filed application, my lord. Application for stay, my lord. In fact, day before yesterday, this matter was listed.
Why in,
My request.
in 9 also it must be there, see?
On my
Because it is
request.
not showing. In 9,
the application is marked to the, I think they are for
9, it is, he's referring to 10. I'm asking 9, there is a stay petition or not? Take the file. RPFC 242. It is not there. Yes, in 10, RPFC 252.
Yes, my lord. Yesterday, I have filed my application, my lord. Day before yesterday, I had requested for 2 days' time. And yesterday, I have filed the application.
Yes,
my
yes, let's see, let's see. If it is not there, we'll call for it.
10 also there is, they are
Uh,
not,
Ask them to send it, pass over.
lord. Grateful, my lord.
Yes.
cell number 11,
For the petitioner, my lord, the
How much is granted?
18,000 per month, my lord, 10,000 wife and 8,000, the
18,000 is, what is your income?
income is 40,000, my lord.
What is
The-
wrong in it?
The petitioner, my lord, the age of the parents' age is 70 years,
Then
65
who
years.
will
my
take
lord.
care of the
My
wife
lord,
and
per month, medical expense, my lord, 30,000 per month, my lord.
Who's medical expenses?
My lord, the medical expense, father of the petitioner, my lord. The respondent also, my lord, she was working as a private company, my lord. She was earning member, my lord, 30,000 per month in salary, my lord.
Then why did the court grant maintenance to her?
My lord, my lord, the resolved documents, my lord, the.
Please come and counts for the petitioner submits that though he's getting income of 40,000.
Yes, my lord.
He has to take care of his parents and their medical expenses are coming. He is paying the heavy chunk of the salary is going towards that. Considering the same, they shall be stay of all further proceedings on the condition that the petitioner shall pay 12,000 per month towards the maintenance of both the petitioner, both the respondents. And the arrears also same, the default order. He has notice to the respondent. Well,
Yeah, Madhusudan Rao, Lord's 50,000 maintenance is awarded. They were married and lived together only for 25 days
50,000 is awarded to the wife.
to the wife.
What
Lived
is
on-
your income?
Income, my lords, I am residing in the US. They claim 15 lakhs, my lords. My client states that he is not earning so much. He was not allowed to even adduce evidence. What had happened, he had appointed his father as the power of attorney holder. His father was diagnosed with
What we
prostate
do is, in
enlargement.
this matter, any of your client is working in US, let notice go to the respondents, will decide not a case that you are not in a position to pay.
My lords, 50,000, my lords, I have educational loans to pay. My father is hospitalized. Prostate enlargement, he has undergone
It is
surgery.
submitted that the court had granted 50,000 as maintenance on the ground that the petition is working outside. And they have stated the marriage law has lasted for a very short period. Further, he has the medical expenses of the parents to be borne. And also the educational loan installments he has to pay. Considering the same, they shall be stay 25,000 notice.
Please,
And the
please.
arrears also at 25. Yes.
Much obliged.
With kind permission.
No mentionings now.
This matter was supposed to be posted today as per the direction of this honorable court. In spite of that, my lord.
Why? What is that? Ask the court officer. Look at it, what it is.
Scrutiny bench.
The published,
Get given back.
Date ನೀವು ಇವತ್ತಿಗೆ ಅವರು ಅಲ್ಲಿ ಇಟ್ಕೊಂಡು ಅಲ್ಲೇ ಕೂತಿದ್ದಾರೆ. ನಾನು ಇವತ್ತು ಹೋಗಿ ಹೇಳಿ ಬಂದೆ ಬೆಳಿಗ್ಗೆ ಇವ್ರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೆ ಹೋಗಿ ಹೇಳಿ ಅಂತ.
Okay.
Court officer, madam. Court officer, madam. Court officer, madam.
That is the problem.
ಅಂಡರ್ಶೀಟ್ ಅಷ್ಟೇ ಸರ್ ಆಗಿರೋದು ಮೇನ್ ಆಗಿ ಮಾಡಕ್ಕಾಯ್ತಲ್ಲ ಅಂತ ಹೇಳಿ ಅಂಡರ್ಶೀಟ್ ಆಯ್ತಾ ಇಲ್ಲ ಏನ್ ಮಾಡೋದು ಅನ್ಸುತ್ತೆ ಅಂಡರ್ಶೀಟ್ ಟೈಪ್ ಮಾಡೋರು ಟೈಮ್ ಆಗುತ್ತದೆ
ಹೋಗಿ ಫೋನ್ ಮಾಡಿದೆ ಮೆಮೊ ಕಳಿಸಿ ನಾಳೆ
ಯಾವ ಮೆಮೊ ಕಳಿಸ್ತಾರಂತೆ
ಫೋನ್ ಎಲ್ಲ ಎತ್ತಿಟ್ಬಿಟ್ಟು ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬಿಟ್ಟು ಬಂದೆ ಈಗ ಕೋರ್ಟ್ ಆಫೀಸ್ ಕರೀತಾ ಇದ್ದಾರೆ ಅಂತಂದೆ ಅದೇ ಕೇವೇಟ್ ಇದ್ದಾರೆ ಯಾಕೆಂದ್ರೆ ಮಧ್ಯಾಹ್ನ ಬರಕ್ಕಾಗೋದಿಲ್ಲ ಕೇವೇಟ್ ಇನ್ಫಾರ್ಮ್ ಆಗೋದಿಲ್ಲ ಅದರಿಂದ ನಾಳೆ ಕುಟಪ್ಪ ನಾಳೆ ಬಂದ್ಬಿಟ್ಟು ಅಲ್ಲ ಒಂದು ಮೆಮೊ ಬರ್ಕೊಟ್ರೆ ಸಾಕು ನಾನೇ ಕೊಟ್ಬಿಟ್ಟು ಅದು ಪುಟಪ್ ಮಾಡಿಸ್ಬಿಡ್ತೀನಿ ಅಯ್ಯೋ ಮಾಡೋದು ಬೇಡ ಅದೇ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡೆ ಆಮೇಲೆ ಬರ್ಲಾ ಊಟ ಮಾಡಿ ಮೇಡಮ್ ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ ನಾಳೆಗೂ ಮಾಡೋದಿಲ್ಲ ಆಮೇಲೆ ಯಾಕೆಂದ್ರೆ ನಾಳೆಗೂ ಮಾಡೋದಿಲ್ಲ ಬೇಕಾದ್ರೆ ಮೆಮೊ ಇದ್ದವರು ಊಟ ಆದ್ಮೇಲೆ ಬೇಡ ನಮ್ ರಿಕ್ವೆಸ್ಟ್ ಕೊಟ್ರೆ ಅಂತ ನಾನೇ ತಗೊಂಡು ಕೊಟ್ಬಿಟ್ಟು ನಾಳೆ ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ ಒಂದು ನಿಮಿಷ ತಕ್ಕೋ previous one. What was last one? 2nd of September. But the file is not reached pending till now.
ಆಫೀಸ್ ಅಪ್ಲಿಕೇಶನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದ್ದೀರಾ ಸರ್
ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್
Now we send the letter to the present bank. My book is there. You verify it. Then we send the letter to present bank. ಎಲ್ಲ book ಅಂತ ಆಗಲ್ಲ.
ಯಾವುದು ಇನ್ನೂ ಹೋಗಿದೆ ಬಂದಿಲ್ಲ
We send the letter to the present bank. Book is gone there only. Otherwise you come little afterwards.
Last 3 days I went there and I copy. Please tell me that no one is in court.
Sir, they are not giving the correct statistics. We will not give second while we have to keep with our steps.
Whatever was revised on 17th October.
There
was some problem so it was amended on 17th October.
So that's it.
Civil minister.
Unless verify the book, we can't tell anything. We have to verify the book. ನೆಮ್ಮದಿಯಾಗಿ ಮುಂದಕ್ಕೆ ಹೋಗ್ಬೇಕಲ್ಲಪ್ಪ.
ಕೆಲಸ ಆದ್ರೆ ಯಾವುದೇ
ಇನ್ನ ಅಷ್ಟೆಲ್ಲ ತಿಳ್ಕೊಂಡಿದ್ರೆ
ಶುಕ್ರವಾರ ಮುಂದೆ ಇತ್ತು
ನಾನು ಅದನ್ನೇ ಹೇಳಿದೆ. ಹಾ
ಸಾದಿಕ್ ಗೋಡ್ವಾಲ ಅಜ್ಞ ಅಪಿಯರ್ ಆಗಿದಾರ ನೋಡ್ತೀನಿ ರೀ. ಯಾರೋ ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್ ಇಲ್ವಲ್ಲ? ಇದಾರೆ. ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ VC.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಮೇಡಮ್ ಜಸ್ಟ್ ಮಿಸ್ ಆಯ್ತು ಸಾಹೇಬ್ರು ಮುಂದಕ್ಕೆ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ರು.
ಒಂದ್ ನಿಮಿಷ. ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್
3 ಮೇಡಮ್.
3 ನೋಟಿಸ್ ಆಗಿದೆ ಸರ್ ಅದು.
ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್ ಮೇಡಮ್.
It is RPFC 52 of 25 ತಾನೆ?
ಕರೆಕ್ಟ್ ಮೇಡಮ್ ಕರೆಕ್ಟ್.
That is notice is ordered.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್. ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
Third list full कर दिया था.
ನಾಳೆ ಸರ್ 9 ಪಾಸ್ ಅವರಾಗಿದೆಯಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 5 ಕರಿತೀರಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್
ಅಲ್ಲಷ್ಟೇ ಓಡೋದು ಸರಿ. ಹ್ಮ್ 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 ಹ್ಮ್
ಅಲ್ಲ ಸರ್, ಧಾರವಾಡ ಬೆಂಚಿಂದ ಕನೆಕ್ಟ್ ಆಗಿದ್ದೀರಾ ಸರ್ ವಿಸಿಗೆ? ಎನಿಬಡಿ ಜಾಯಿನ್ ಟು ವಿಸಿ ಥ್ರೂ ಧಾರವಾಡ?
Madam sir, list number 5 ಕರೀತೀರಾ?
ಸರ್ ಆಲ್ ಲಿಸ್ಟ್ ವಿಲ್ ಬಿ ಕಾಲ್ಡ್ ಔಟ್.
Okay.
ಎಲ್ಲ ಕಾಲ್ ಮಾಡ್ತೀನಿ.
Okay.
also. Yes.
Paying for the petition of my lord.
So what is that clarification? I didn't understand. I've seen it.
My lord,
Court already said that it is between 10 to 5.
no, my lord, the trial code is 10 to 1, my lord. Your lordship was modified to 10 to 5 p.m. That is not forthcoming in the
What is that?
operative portion, my lord.
That order is not there. Supreme Court. Just now I've seen asked Mega to send it. That order. It will be called.
Please.
Ask Mega to send that.
Look, I'm restricting my prayer to on
For
IA
the
number 12 minutes.
Respondent in this case.
Yes.
Minutes. In this, the petitioner had filed two IAs.
A number?
IA number 12. That's it.
What is I number 12?
IA number to produce additional witness minutes, list of witness.
Where is it? Order?
That is at order is at page number 16 minutes.
Yes.
That is common order on IA number 11 and 12. Minutes. IA is at page number 60.
You are the
I am the petitioner.
wife or husband?
Husband.
Who filed the MC?
MC initially minutes for conjugal rights. Husband had filed a petition minutes. Thereafter, wife files a petition for divorce, which were clubbed together. Both the petitions were.
Both are of the year 2023.
One is of the year 22 and one is of the 23.
You have filed in 22.
22.
You are for the husband.
Husband. I had filed it for restitution of conjugal rights. And after filing of the objection in the year 23, the respondent wife files an petition for divorce.
When is the evidence closed?
It is just on 2310 minutes. I'll take you to the page number 12 minutes. 12 of the writ petition. That is minutes on 22/9. What happens is counsel for the respondent, that is wife, files IA number 8 under section 151 of CPC seeking to reopen the case. IA number 9 under order 18 rule 17 CPC seeking recall RW1 for further evidence. And I say there is no objection. So IAs are allowed minutes. On 23, I had cross-examined. On that day, Milords, certain document, that is exhibit R12 to R35 were marked. And during the course of cross-examination, she has denied many photographs of hers as well as certain things, Milords. So that's 25/9. That is the next day I file an application, to reopen the case for under IA 12. That is order under rule 1 CPC.
No, this is how it goes on.
No,
not today. You will this IA will be allowed. You will examine. She will deny some more things, and for that you will again ask the court to reopen it, and you will.
Because she has specifically her own photograph she has denied, Milords. The reasoning is at page number 16.
No, I understood. Let's see the order of the court.
Please, Milords.
So this IA number. Now you are restricting it to IA number
12.
12. 12 is to reopen.
11 is to reopen.
11 is to reopen, Milords. 12 for
list of witness.
List of witness, Milords. Produce list of.
If you insist for 12 without 11, how can this court hear 12? Unless the case is reopened, there is no question of reducing evidence by.
I'm seeking for interim prayer here, Milords. Meanwhile, I'll file an fresh petition and seek.
What is one thing I'm telling you? I will not grant any stay of proceedings of the MC in any of the matters
today,
for whatsoever reason.
Today is the argument, because the finding of the trial court, Milords. Kindly come to page number 16.
Yes. I can pass a final order, but no interim order.
Sorry, ma'am.
I will pass a final order, no interim order.
But today morning, for the reason.
No, I'll hear it. I'll hear it and pass orders then. Argue on the merits of it. Because
because
I will not say
trial
that.
court also, it's matter of 23, my lords, because
Maybe.
she has
So-
made certain grave allegation against me in the petition. When I am putting forward any question, my lord, she denies. That is forthcoming here also, my lords, in the order itself. That is at page number 16.
Read. It's a small order, read from the beginning.
Please, my lords. Both these IAs are filed by the applicant petitioner under section 151 of CPC seeking to reopen the case and under order 16 rule 1 of CPC by furnishing witness list. The applicant or petitioner has urged in the affidavits filed in support of IAs that during the cross-examination of RW1, she has denied all the suggestions, including photographs, which were confronted to her, in which she is seen, and to prove the true facts, the evidence of the witnesses is necessary, and hence the applicant has sought for a leave to examine the witnesses named in the IA. The respondent, on the other hand, filed common objection to the IAs, denying the ground urged therein, and contended that the statement given during the cross-examination cannot be made as a ground to examine the witnesses unless it is shown that in their evidence is relevant. It is further contended that there is no law forbids the petitioner to prove his case on the evidence on the opponent after completion of evidence from both sides and when the matter is set down for final arguments. It is further urged that merely because RW1 is
white.
Yes, RW1 is white. It is further urged that merely because RW1 has not answered according to the desire of the petitioner, that itself will not give the right to him to examine and witnesses, and therefore the application is sought to be rejected. The applications are opposed for another reason, that while concluding his evidence, the petitioner has not reserved any right to lead rebuttal evidence, and therefore the respondent has sought for dismissal of the IAs. Heard on IAs and pursued grounds urged therein. It is revealed from the records that the conclusion of evidence of RW1, the matter was set down for hearing final arguments, and at that stage, present IAs came to be filed. No doubt the applicant has sought for examination of witness for the reason that RW1 had denied her photos which were confronted to her, in which she is also seen, and therefore to prove his case, PW1 is intending to examine the witnesses. But merely because RW1 has refused to answer or admit these photographs, that itself will not give rise to examination of witnesses who are not stated in any manner related to the marital status issues involved between the parties, because nowhere in the entire affidavit of the applicant he has stated as to whether these witnesses are in any way connected to the dispute involved in this case between the parties, except stating that the applicant has to place true facts before the court through these witnesses. It is not at all stated as to how their evidence is relevant to decide the present case. The affidavit is also totally silent as to on which aspect the evidence of these witnesses need to be adduced. Merely because it is matrimonial proceedings where strict application of CPC or Evidence Act cannot be insisted by the court, that itself will not entitle the parties to seek for examination of any witnesses.
Where is your IA?
IA is at page number 60. I do agree, my lords, there is nothing in the IA, my lords. That there is no reasoning given.
There is nothing in the IA, there is nothing in
At
the.
least liberty, my lords.
No liberty, no liberty. Stop. The presented petition is filed.
My lords, one liberty in the sense, on the very same day I'll produce them, my lords.
Presented petition is filed, questioning the orders passed at I number 11, I number 12, dated 8/10/2025, whereby the petitioner sought to reopen the case to examine the witnesses. The petitioner before this court is the husband. Husband had filed MC 420 of 2022 seeking restitution of conjugal rights. The wife had filed MC 719 of 2023 seeking divorce. Both the MCs were clubbed and the evidence was closed on 1/7/2025, correct?
23/9/25. 23/9/25.
23 9/25. No, some date was,
Thereafter, she
concluded long back from, on 1/7/2025 is what is the observation?
that was initial.
Concern with respect to the husband's evidence. That was concluded. Then subsequently, the wife was examined in
Her
chief, and
evidence
then
was
final
concluded on?
last 23/9/25. After that, it was posted for arguments.
Husband's evidence was concluded on 1/7/2025, and the wife's evidence was concluded on 23/9/2025. In between, on 22/9,
one submission. That application wife files to reopen the case. That was allowed.
in between, on 22/9, the wife had filed an IA under section 151 CPC, seeking to reopen the case and to recall RW1 for further evidence by producing the, what are the documents that you have produced at that time?
No, we have not, I'm not very, which is the page number? Can you please tell me?
13,
Page number 12.
Page number?
12 and 13. They
12
marked
bottom.
R12 to R30.
12 bottom.
Page number 12.
12 bottom.
Look at the order dated 22/9/25.
Yes, my lord. Counsel seeking reopen the IA number. For the evidence. I have to take instructions on this, my lords. Well, I'm just aware about this particular thing.
I was under the impression that this application is by him, which is allowed earlier.
Now, his application was filed after my cross-examination and having
No,
marked
on
he
22
confronted with certain documents.
No, on 22/9/2025.
Yes, ma'am.
You have adduced some new evidence?
Please.
No, but so after that was given on his insistence that he has shown that has been admitted.
No, please tell the court.
Yes.
What I want to know is this
Yes.
22/9/2025.
Yes.
What are the documents that are adduced by you?
I'll have to take
Further
instructions,
evidence.
my lords. First date is coming
Further
up, so I have to take instructions. my lords.
Tomorrow.
Yes, my lords.
My lords, matter is today the matter has been posted.
Nothing will happen. What will
Passed
happen?
over for arguments, my lords.
Huh?
It is passed over again for arguments today.
So you're so sure that the court is going to grant order? Tomorrow, let it, you inform the court that we will proceed tomorrow.
Yes.
Yes.
Till number 9, Ajit Teddy.
Not for the petitioner.
So, number?
Where, there are two interim maintenance passed against the petitioner where we have challenged only one against a respondent, direct the petitioner to pay 5,000 interim maintenance. We are complying the other maintenance part of 3,000 which has to be paid to the daughter. My lord, my income is 30,000 and I have a loan liabilities around 25 lakhs which I am paying, for which I am unable to pay interim maintenance of 5,000. It may be reduced and
How can it be? You say your salary is 30,000.
Yes.
You can take 35 lakhs loan, but you
no,
cannot
no.
pay
It was
8,000.
used for my ailing father, for kidney transplantation. It was available
How will
long
they-
back.
Is your wife working?
Yes, she is working as a
Where
teacher.
is the evidence? Let's see. Let's see from the order.
But in her affidavit, she has not stated that she has.
Then you must have placed some evidence. Without that,
And
your
it may-
assertion can't be.
My lord, kindly have it tomorrow. We'll place a record
You
regarding.
can't place all that here. You have to have placed it before the trial court. You have not chosen to. And 8,000 maintenance or 5,000 that is granted cannot be stayed.
No. 5,000 may be stayed and I will pay the rest of it. Let them come before this court and
Why?
file the affidavit and
No,
say
no.
she is not working.
Not necessary.
She is working in a.
Unnecessarily, you don't pay maintenance. Why should we issue notice?
No,
Why
we are ready to
why
pay.
Why should
Otherwise,
she engage an advocate?
It may be reconsidered and it may be reduced to.
I am ready to reconsider now itself. There is nothing to
Yes,
reconsider. 5,000 rupees.
No, my lord, there are so many liabilities to meet. I have to look after my ailing mother.
This is also one of your liability to pay.
Yes, I am looking after my child also. Even I paid unaccounted of
30,000 income, 8,000 maintenance, nothing to interfere.
No, my lord, it may be reconsidered and it may be reduced to half. At least
So
3,000.
4,000,
3,000.
both of them will live on 4,000,
No,
you
no,
will
no,
have
no.
30,000.
I will pay separate to the daughter. I will
Huh?
comply with the order.
3,000
tenancy.
rupees, you're feeling as if that you are doing lot of.
No, no, no. Even I look after the school fee and everything. I'm ready to pay to my daughter.
Hmm.
In wife, 5,000, it may be reduced for 3,000, and it may be ordered. Even I filed a restitution of conjugal rights also. So she is not appearing there. Maybe reconsider.
Tell your client that I'm going to dismiss it. I'll do it tomorrow. This is the matter tomorrow next.
Cell number 10. Cell number 10.
Yes.
What I could make out, as I stand on records that the calculation is with respect to the year of 2020-24, I had a conversation with the petitioner over telephone. If I may place it orally, my lords.
Yes.
As of this year, that is with respect to the daughter who is staying with the mother, the educational expenses per annum comes up to 1.2 lakh. The additional 30,000 is with respect to the tuition which the mother is sending or not. As and when she has demanded, he has sent with respect to tuition. So it would come up to between 1.2 lakh to 1.5, which I would restrict to 1.2 itself, which the other 30,000 is
1.2 per
lakh
annum.
per annum.
To both.
To the daughter is with the mother, son is with the petitioner, that is the husband.
Hmm.
Then with respect to the son, at about 1.5 lakh is the educational expenses per annum.
Hmm.
Then additional at about 50,000, which would include tuition and basketball coaching, which he goes for sports. That is again fluctuating 1.5 to 2 lakh.
2 lakhs per annum.
Please.
So all put together, it is 3.2.
Please. Then further, I am in a rented accommodation. My own house is with the wife. I've given up that accommodation to her, and I will go on to state that I will not dispossess her till her lifetime. Even whether divorce is granted or not, I will not dispossess her. I continue to pay the maintenance of that house with electricity, gas, water, and the annual maintenance charge that is raised by the community, that is the association which they would raise. That would come up to between 60,000 to 80,000 rupees. That is in respect of the maintenance of that particular property. That is inclusive of again the monthly maintenance which they deduct. So somewhere between 60,000 to 80,000 is raised. Then the yearly maintenance as of 10,000 if considered would come up to around 1,20,000 rupees.
That you are
per
not
annum.
paying regularly.
Please, that I'm paying regularly. That I'm calculating per annum.
Just recently, last week, my lord, based on the interim order that the lordship would please to grant at the beginning of this case, it was 10,000. Just last month, somewhere this week, they paid about 30,000, and there is no certainty on there's no timely payment, and we have no guarantee that this 30,000 is just before the case of the hearing, or is supposed to last for the next 2 months as well, including this month.
I'm sorry, I should clarify.
There was no clarification given by the husband in this regard.
I have a clarification with that. 10,000 is what is her monthly maintenance. That is regularly paid. I will put.
So what is your salary, you said?
2 lakh is now the take-home salary. But with respect to 20,000, which they want a clarification, that is with respect to the mother.
So with the tuition fees, I mean, with the school expenses, that comes to around 26,666. That is 27,000 approximately for the month.
Please.
For the month.
Please.
You are paying another 10,000.
Please.
To the wife.
Please.
As per the order of this court. So you are spending an amount of rupees 37,000.
Plus my rent. I stay in a rented accommodation. I paid 40.
I'm saying about what you're spending towards them.
Please. Well, with respect to 20,000 additionally, which was paid by the husband, that was
for what?
The mother informed the father, stating that the daughter wants to undergo a dental surgery. She demanded money, it is sent. Additional 20,000 is sent. But till date, not a single rupee of maintenance is denied to her as per the order of this court. That has been promptly paid. I'll place it on affidavit if so required.
What is granted by impugned order?
1 lakh. 1 lakh, as against 1 lakh, I had challenged. Now, on earlier occasions, I had made a statement before this honorable court that with respect to the children, even if they even after attaining majority, whatever the expenses that could come up for their education, whether they want to study here or abroad, I will bear it. The father will bear it. The mother will not be dispossessed from the house that belongs to me. I'll continue to pay the maintenance of that particular house.
So we'll alter the order like this. The entire educational expenses, medical expenses, extracurricular activities, pertaining to the daughter, the father will be taken care of.
Please,
Whatever is the amount.
please. My lords,
Whatever is the
whether
amount.
they give me the
Whatever is
receipts or not,
amount.
I will not fight with them.
Whatever is the amount. And apart from that,
Please.
30,000 per month, you pay towards their maintenance. They have to live, isn't it? Is she working?
My lord, there is an order passed by this honorable court. What happened is, just to point out her conduct, during the pendency of this writ petition, once I obtained an interim order of stay, what happens is she quits from the job, she resigns. Then she comes to this before the trial court, she admits that she has a 40,000 income per month.
You're working.
She was working.
She was working.
She was working.
Why she
But given
left the job?
Given after this court was pleased to grant the interim order, my party had to take care of her parents and children as well and regarding their
What
medical
children?
expense.
One child is
One
with
child,
them?
yes, my lord.
This is what
The
my
child has
lords,
medical ailments to be taken care of. The child has medical ailments to be taken care of. The respondent herein has parents to be taken care of. And there is also another issue, my lord. Even before the trial court, umpteen opportunity was granted to the husband to file their list of assets and liabilities, which
Forget
was not
about
done.
that. Forget about it. No, for the sake of taking care of the parents, if you leave the job, who will take care of them? What about the
My lord,
financial?
that is exactly the dilemma. I have been put in a position where I have to choose between working or caring for my family, which has become impossible to do both at the same time. And my party has taken a decision
I'm sorry, I'm interrupting.
to care of a
Please
family,
wait.
to take care of her family in this respect. My party has made a decision because here it was difficult to manage her job.
So you
as well.
want, do you want the entire expenses that are pertaining to your parents and everything to be taken
So
care?
those have not been computed, my lord.
Hmm.
The only expenses that have been asked for the children and the
Then who
wife.
where from you're getting to take care of your parents?
We have borrowed from friends and family. It's been placed on affidavit as well, my lord. The affidavit filed on the last date of hearing. We say that we've borrowed from friends and family extensively, if I may say so. And to that extent, that is the income that they're surviving on right now. Because this was a choice taken by the respondent herein. Even though it was a difficult choice, this is the choice that she has chosen to take. And even if I'll just make
The choice is difficult to him. Why to you?
difficult because she had to choose between her job and her family.
No, but
That
you're
was a dilemma
comfortable.
placed.
Whatever you paid, that 40,000 now you're getting from him.
My lords, it is like this, my lords.
My lord,
to the
that
earlier-
order was passed in lieu of even the respondent wife working, despite even considering the fact that she was working, a maintenance of 1 lakh
Rupees
was
is
wrong.
a very exorbitant amount. 50% of the salary under which law has to be granted
My
towards
lords, if I may make a
maintenance.
submission, that's not 50% of the salary. Page number 76.
Lords, for 4 years, she has taken care of the child with the same salary. Just because an interim order is passed by this honorable court, she resigns. Then again, she comes before this court once this honorable court passes an order.
For 10,000 she resigns.
Please, that is what happened. My lords questioned the earlier counsel who was there on record, questioned him as to why she had to quit now. Then, and directed her to place an affidavit as to why she quit. Now she filed an affidavit stating that she has been reinstated to her job and she's continuing there. Now again, she has quit. That is just to show us that
In the deductions, if your lordship may look at it, there's provident fund, professional tax, gross income is 4,27,971.
I'm
Income
sorry,
tax paid.
there is a revised salary slip that is filed along with the.
No, my lord, even regarding the old document, income tax paid is 2,52,000 on a salary of 4,20,000, that is nearly 50% income tax. Income tax payable for that assessment year would amount to approximately 10,50,000. The husband here has blatantly lied regarding all their expenses and only statutory deductions are permissible. There are various judgments to this effect, my lord, if I may produce them.
What are your expenses?
I placed them on the affidavit, my lord.
This where is it?
As I'm willing for any reasonable revision on that order.
Yes,
I
where is
continue
that?
to pay with respect to the expenses.
Yes, yes. Where are your expenditure?
I placed it on an affidavit, my lord.
Date, there must be a date. There are so many objections, so many papers are here.
August.
Something is dated 29/2024. Is it so?
No, my lord, this year. August of 2025.
Nothing is there on record. August of 2025.
Let's be about the 20th of August. Because we have served a copy on the petition as well.
Have an extra copy, give it to the court.
No, they've served it to me on WhatsApp, but I have it on WhatsApp. That is the issue. I'm not sure. Because I'm not sure whether that is the affidavit which my friend is referring to, because on 19/7/2025, one affidavit was served on me, and I have acknowledged that service.
So that was
What that affidavit says, what is your income?
My lord, in terms of expenses, His Lordship.
Expenses.
Expenses, my lord. 2,000 rupees towards electricity charges, 1,500 towards water bill, 1,000 regarding internet charges, 1,000 pertaining to cable and other charges. Then 8,000 for the cook, 1,000 for the petrol, 2,500 for miscellaneous expenses, 3,000 for yoga classes. 2,000.
Sorry, let him read it, because 2,000 says for spa and saloon.
Coming to that, man. I'm coming to that.
It says miscellaneous. He says
Coming to
2,000
that.
for
I'm
spa
coming to
and
those
saloon.
parts. Yoga
Please.
and the other more subheadings, my lord. I'll come to that. 3,000 for skincare products.
No, 1,000 is?
1,000 is for mobile recharge, mobile and internet services. And there are two headings. There's mobile recharge and internet. 1,000 rupees. There is 2,000 rupees towards electricity bill, 1,500 towards water bill. There is 14,000 towards 14,800 towards housemaid, 8,000 rupees towards the cook.
14,800 towards housemaid.
Housemaid. 8,000
Hmm.
for the cook, 1,000 for the petrol, 2,500 for spa and salon expenses.
What will you do? You have a housemaid, you have a cook at the expense of husband, and you don't work, and you have taken a decision that you will not work. What is it? How is it reasonable?
A lot, because some of these expenses, because they pertain to even the child and the parents of the wife herein.
Parents
it's
are
not
his
just for the wife.
Parents are not his responsibility. Your parents are not his responsibility.
Yes, my lord.
Yes.
My lord,
No. Please further tell the expenses.
8,000 for household expenses towards groceries, 4,000 for fruits and vegetables, 10,000 for eating outside, 1,000 for
10,000 for eating outside.
1,500 for puja items, 12,800 for apparels and accessories, 4,000 for stationaries, 15,000 for medical expenses, 10,000 for backache treatment and asthma treatment, and rupees 10,000 for toiletries and other miscellaneous expenses. I'm also required to pay an amount of 50,000 towards insurance for the minor child and 48,000 for medical insurance of my parents. Also, I require a small car. My lord, if I may offer an explanation regarding the car. During the course of the marriage and even before the filing of this MC, I had purchased a car, forcefully albeit, in the name of my husband, and that expenses and that record has also been placed on affidavit.
There are 2 points which I have left out. If I may read, my lords. Kindly see this. 2,500 rupees for spa and saloon. 3,000 for yoga class. 3,000 for skincare products. 2,000 for cosmetics. 1,000 for laundry. 8,000 for household expenses. 4,000 for fruits and vegetables. 10,000 for eating outside. 1,500 for puja items. They go on and on. Skincare.
You mentioned them, my lord. We have not skipped over any
salon.
item.
No, I'm sorry. He has not read it.
We have mentioned spa and salon and those other expenses as I was reading through the affidavit.
The affidavit is not on record. That is the reason. I had to read it out. I'm sorry.
Please come.
Along even the outstanding purchase of payment of buying of a car for my husband with my money.
What is that amount? What is the
I
EMI
dispute
per
that.
month?
Please, I dispute that.
Huh?
I dispute that. There is no such purchase that has been made. It is a.
Car is with whom?
The husband.
Malazar, I'm sorry. There is no such vehicle.
My money has been used to buy him a car. And regarding the same, because 2,52,000 has been shown as income tax.
What is the EMI I asked you?
Malazar, there is no. This is date this transaction way back to the time of marriage.
We were gifted a car worth
12 lakhs.
12 lakhs.
No, that will be decided when your MC is decided, your alimony is decided, then it will be. No, for the purpose of maintenance, all those things will not consider.
Well, the car is worth about 5,60,000.
That in the pending MC proceedings, the court will deal with it. Very simple, Nora.
My lords, impugned order is at page number 62, my lords.
My lord, because umpteen opportunities were granted to file his assets and liabilities and
But
they've
I
not
did-
been granted. As per para 66 of Rajesh and Nehan, adverse inference must be drawn
My lords,
in this
I
case.
filed-
Umpteen opportunities have
Also,
been granted.
adverse inference also should be drawn on your client for giving all these expenditure.
Lord-
Agreed with orders passed in I number 3, in MC number 3/111 of 2020, dated 25/9/2023, whereby the court had granted an amount of rupees 1 lakh towards the maintenance of the mother and the child. And also the educational expenses. The husband is before this court. Who has filed the MC
My lords, husband's MC.
Husband.
on the ground of?
Cruelty.
MC number 3/111 of 2020 is filed with the husband seeking divorce on the ground of cruelty. In that, the wife had filed I number 3 seeking maintenance of an amount of rupees 2 lakhs per month. As on the day when the IA is filed, the wife is working and earning 40,000 per month. It is the case that she has to take care of the parents, and also the child who is having medical needs. And a list of the expenses were given. According to her, her husband is earning an amount of rupees 4 lakhs per month. The family court had granted the maintenance, and while granting, the court has observed that in spite of giving sufficient opportunity, neither he has filed his objections to IA number 3, nor he has filed his assets and liabilities in order to deny the claim made by the wife. Hence, the court had granted the maintenance. Looking at this husband, the standard of considering the 4 lakh salary as stated, an amount of rupees 1 lakh is granted. When counsel appearing for the petitioner husband submits that in the wedlock they're blessed with 2 children. The boy is with the father and the girl is with the mother. The property which she has purchased is given to the wife, and she has been living in the said property. She is living in the said property. It is submitted that the husband is taking care of the entire educational expenses, and whenever she asks for any amount, he has never denied the same. It is submitted that the court and his take-home salary is 2 lakhs, and he has to take care of the other child, and the amount of maintenance that is awarded by the court is on the higher side. When counsel for the respondent submits that, as the petitioner has failed to file his statement of assets and liabilities as per the judgment of the apex court in Rashish versus Neha, the court had rightly drawn an adverse inference and granted an amount of rupees 1 lakh. It is submitted that after filing of this petition, the wife, as she has to take care of her parents, she has left the job. Now she is entirely dependent upon the maintenance that is paid by the husband. The petitioner, the respondent, has given the amounts, that is the expenses, which are coming to 2 lakhs.
Yes, ma'am.
Coming to 2 lakhs, which includes her yoga classes, for her maid, for the cook, for eating outside. and the amount that is incurred for taking care of the parents, everything is included, and she requires 2 lakh rupees. It is submitted that though her requirement is 2 lakhs, court had granted only 1 lakh, and there are no reasons to interfere. Having heard the counsels on either side, there is some material on record. This is an order passed on 25/9/2023. This matter is pending before this court from the last 2 years. According to the husband has filed his salary slip before this court. As per the salary slip, his salary is 40 lakhs. According to him, after the deductions, what is your take-home salary?
My lords, it's 2 lakhs.
It's 2 lakhs. According to the land counsel for the respondent, though all those deductions cannot be taken into consideration, only the statutory deductions have to be considered. Admittedly, the boy is with the father and the girl is with the mother. Father is ready to take care of the educational and also the medical expenses of both the wife and the child.
Please, of both the wife and the child.
Educational.
Son and the daughter.
Medical expenses of
Please,
the wife.
of the wife. Yes.
Educational and medical expenses of the child, of the daughter, and also the medical expenses of the wife. The amount, just because husband is earning 2 lakhs, that cannot be a ground for the court. That is not a ground for the court to grant maintenance of an amount of rupees 1 lakh. While granting maintenance, the court has to look at what are the expenses of the child, expenses of the party, whether those expenses are reasonable expenses. Considering the fact that the house in which the wife is residing belongs to the husband, and he is ready to take care of the medical expenses of the wife and the educational medical expenses of the daughter as it is. In the considered opinion of this court, an amount of rupees 50,000 would be an appropriate amount. Accordingly, the order impugned is set aside. The order dated so and so is modified, and the court is passing the following order. The husband shall pay an amount of rupees 50,000 by 5th of every succeeding month, and the arrears, if any, shall be paid within a period of 8 weeks from the date of receipt of the copy of the order. The husband shall bear all the educational expenses of the daughter and the educational and medical expenses of the daughter. Number 3, he shall also bear the medical expenses of the wife.
My lord, regarding the housing situation, they've given an undertaking that they've given permission to reside in the
I will
house.
not dispossess her. That undertaking may be taken.
The husband undertakes before the court that he will never dispossess the wife. It is submitted on instructions. It is in his arguments. It is submitted that the husband will never dispossess the wife from the said property, even after the MC proceedings.
Till her
lifetime.
Till her
During her
lifetime.
lifetime.
Till her lifetime.
Till her lifetime.
Please.
The same in the point number 4.
Lords, if I may request, 50,000 would be exorbitant. Why is because she has another sari business also. That also I placed on record. She's a GST holder. Lords,
Yes.
it may be any.
If
My lords,
again you argue on that, we have to go to the adverse inference part, and 2 lakhs we have to grant.
any minor revision, if I may request, my lord, I'll be able to justify to my
Already
client.
court has exercised the discretion. Yes.
Please.
Yes, next.
Grateful, ma'am. Obliged.
Yes. What is that order copy? Yes. Lanka, the matter is placed before this court and the caption for being spoken to. Land counsel submits that when this court has dictated when passed an order on 26 September 2025, this court has specifically observed that the family court had granted visitation to the child on every Sunday between 10 a.m. to 1 p.m. However, 1 p.m. and this court has extended it to 10 p.m. to 5 p.m. The same is not reflected in the order. There is no representation on behalf of the respondent. This court has has looked at the video recording, which clearly shows on that day the court had dictated that it should be between 10 to 5 p.m. on Sunday.
On
In
every
the light
Sunday,
of the
my lord.
same,
On every Sundays.
on every Sunday, in the light of the same, at paragraph number 3,
Please.
on every Sunday, father can have visitation.
Sorry, with respect to serial number 10. Serial number 10, my lord. Payment of arrears from the date of
Application, my lord.
clarification can be
The clarification, I don't know, please.
That in the earlier matter, the
The application is dated 19/11/2022.
yes, the arrears at 50,000 shall be from the date of application.
They have paid 10,000 rupees earlier.
Or if any amount is paid, the same shall be deducted.
Please.
For that, you have to file a memo before the
Please,
court
please,
because
please.
unilaterally you can't.
Please, I shall file a calculation along with the arrears. Obliged.
In regard to the arrears, both the parties shall file
joint memo
before the family court in the pending aims. Yes.
Pass over in list number 2, serial number 1. Divya A. Jain.
Lords,
Yes.
the matter is posted for dismissal, my lord, but opportunity must be given to place the facts on record. It's not as simple as the respondent claims it.
No, what opportunity you require?
My-
Dismissal means what? Because you have not come, I will give
My
you an
lord, there was an
opportunity to hear
emergency on that.
today.
I was out of town. I arrived just today, my lords. Live for yesterday. My
No,
lords,
no,
it may be
no, no.
considered. Facts of the case, my lord,
Yes.
they are not as simple.
No, I
It
can understand the
might gi-
complicated facts also. Yes, please tell.
My lord, so, my lords, the EMD was paid in the year 2019.
No, first tell me what is the prayer that you're seeking before the court?
My lord's prayer we are seeking is the EMD amount plus the 15% bid amount which was deposited by the auction purchase.
Mandamus directing the respondent to deliver the vacant physical portion of the scheduled property to the petitioner. To pay to the petitioner interest at the 12% per annum on 25% deposit. You are the auction purchaser.
Auction purchaser, my
What happened?
My lords, so the auction purchaser had paid the EMD amount as well as 15% of the bid amount in 2019, back in 2019. There was an essay subsequently filed in the year 2020 to set aside the possession certificate. Despite of this, the bank went ahead and auctioned the property, my lords. And after that, another essay was filed to which the auction purchaser wasn't a party. Neither was he informed that any such petition is available, your lordship, because I have invested my amount. I have invested.
You have paid the 25% of the amount.
Yes.
Then what happened?
Then, your lordship, after that, we were following up for the possession, for the physical possession of the property from the bank to pay more, to pay the 75% more. We were following up with the bank, your lordship.
But you have to pay it within 15 days from the date of confirmation of sale.
Your lordship, the rest of the amount, only when the bank intimates us, we can pay. It's written in the, my lords, the letter issued by the bank.
Let's see, where is it?
Just. At page number 24, your lordship.
Yes.
The balance 75% of the bid amount of 66,86,250 shall be payable after the physical possession of the property is obtained and within 7 days the obtaining of the physical possession. But the bank had not obtained any physical possession by then. So we were following up, asking the bank that is the physical possession obtained by you. We were ready to pay the 75% bid amount, your lordship.
Every auction will have its own conditions.
Lord, I just point out what had happened. After selling the
Then I think we have to give the concession to your submissions every time.
Here the matter, my lord, what had happened? After selling the property, my lord, borrower approached the DRT. Borrower approached the DRT in essay number 314.
No, I'll tell you the exact submission you make in every case. Even if I want, I can't even give a day. That's what you say. So where from this time is coming?
My lord.
My lords, and subsequently, and
My lord, that particular paragraph from 4, my lord, I just read it. The balance 75% of bid amount on 66,86,000 shall be payable after the physical possession of property is obtained within 7.
Lord, I too agree, my lord, that conditions they
So
would
it
not
is like inordinate, it's running with inordinate delay.
apart from that. Here, I am about to take the physical possession of property. In fact, my lord, there's some understanding saying that when they participate in the auction, there is no, my lord, physical possession with me. In fact, when I am sold a property, they arrayed as a successful bidder. They pay 20% of the money. It is not in dispute. Subsequent to that, my lord, the borrower approached the DRT. The DRT set aside the sale, which I conducted, my lord, therefore, and directed me, my lord, kindly come to.
When was the sale set aside?
Sale set aside on, my lord, 28 February 2023.
28
February 2023.
Then what did you do thereafter?
Thereafter, my lord, kindly come to, my lord, as per the order made by the DRT, you have not followed the procedure. Set aside the sale. In fact, it is recorded that so and so is the auction purchase. Everything is recorded. It's not that, my lord, DRT is not.
Oh, it has set aside the sale without notice to the respondent,
Without notice
to the petitioner.
However, as my lord, kindly come to page number 35 for a moment. 36.
What is happening to the DRT? What is happening to the bank? What
My
are
lord,
these
I
orders?
intimated to the, my lord, kindly see that.
No, when you're set asiding an auction, that means somebody has participated.
Participated.
Then
That is got record.
Without the other person's presence, how can the DRT pass an order?
Matter of fact, my lord, that is got recorded. However, my lord, the borrower, my lord, not choose to, my lord, implement the auction purchase in this matter. That is a matter of fact. Now, my lord, I just point out the order passed by the DRT for a moment, page number 36. The essay number 314 stands allowed, setting aside the annexure A7, auction notice dated 6/7/2019, published in so and so, so and so. Issued to the successful bidder, Mr. Suresh Kumar B, that is, my lord, petitioner. The respondent bank is directed to return the EMD amount to the successful bidder, Mr. Suresh Kumar B, along with 6% per annum to the date of sale according to the law. What had happened, my lord? I returned the money to the, my lord.
In his absence, all orders will be passed.
My lord, the money was also
6% that you have given.
It's a duty of the borrower to, my lord, would have implemented, and DRT would have, my lord, he is aware of the position of, my lord, where auction is already taken place and 25% of the money he is paid. That is, my lord, in DRT terms. Lord, I cannot be penalized for the mistake made by the, my lord.
No, you accept all the mistakes.
My lords, even after the order was passed, after 10 months, was I intimated that such an order is passed and
When
we
was
have
that
given.
intimation from the bank?
Your lordship.
At least it is expected that bank, you have to be at least fair.
In this matter, my lord, DRT got set aside, my lord, my sale. My lord, accepting that order, my lord, I don't take any other chance. At least now also, my lord.
My lord's intimation by the bank was on 14th of August 2019.
No, the bank's approach appears to be whatever is the means to achieve, not important. Let money come to the bank. That's the only thing appears to be. Yes.
My lord's order was passed on 20th February 2023.
2023. When was it intimated to you?
On 14th of August 2019. Your lordship, just a minute. It was intimated on 21st of December 2023.
21st December?
2023. 10 months have still passed, my lord. And
after that, what you did?
I again went to the bank, my lord. We asked them.
When?
My lord, that was on call, but during the pendency of the essay, I wrote a letter to the bank on 27th September 2021, asking the bank, it is produced as annexure F.
27 September?
2021.
Where are you going to 2021?
My lords, this was during the pendency of the essay. I even approached the bank asking what is the status of the auction? When do I pay this?
Yes, come to the release that you're seeking. How will you get this relief when already there is an order by the DRT?
My lords, even if his possession of property is not given for me, 12% interest, DRT has given 6%. I would like to state that I had taken an overdraft facility on which 9.95% of interest I'm paying, my lords. And because of bank's delay, I didn't even know if I am supposed to keep paying the interest. 10 months lapse. In total, 4 years of lapse, my lords.
Yes. What do you say on the interest?
And my lords, even the value of the property, I have produced the valuation sheets, my lords.
No, that the manner of the sale and all, we cannot go at this point of
my
time.
lords, I put the money as investment.
No, you should have questioned it. You should have questioned that order of the DRT.
This order,
My lords,
also,
I'm
my lord,
not a party to
That you
DRT.
can,
this
that you
order also,
can.
my lord, they would have taken up an appeal before DRT because they
I'm
are
not a
the
party
just
before
pointed-
DRT. I have
my lord, whenever-
judgments, my lords.
Then you keep quiet forever.
No, my lords, as soon as we,
Says, what do you say about this interest
But
part?
interest, my lord, he purchased the property as is varies. DRT set aside the auction, my lord, conducted by me. No, my lord, I am not in the position to pay the interest because whatever DRT passed in order, we complied it and we paid it, and which is there accepted.
No, for they say that they have availed the overdraft
That,
facility.
my lord, auction for every auction, my lord, auction purchases, they will take their own risk when participating in the auction. It is the, my lord, public auction, it is some pros and cons or some risk is with them. They are fully aware, then they purchase the property. After that, it is not, my lord, I am not set aside the, my lord, sale, but DRT, my lord,
A day will come, nobody will participate in
that,
the.
my lords, even the
Organization
bank
will
is
come to
supposed
a
to be
standstill.
responsible towards the money they
I
are
am-
taking, my
lord,
lords.
I'm fully conscious, my lord, in this, my lord, my lord, the borrower have a right to go under section 70, which, my lord, we appeared and we filed a statement of objection, we tried to justify. Still, my lord, DRT set aside. Either, my lord, if somebody agreed, they would have gone before DRT, asking some more relief before this, or this order also can be a sale under section 18, that benefit, my lord, can be encashed by the, my lord, the petitioner. Because they're not the party in the DRT. No, my lord, my respectful submission, my lord. The order passed by the DRT on February 2023, which we duly complied. We paid the money to the, my lord, borrower, sorry, petitioner. No, my lord, either he's having an option to take up this order before the DRT because they are not the party, or, my lord may relegate the
No,
matter
this
to-
is a fit case where this court will exercise a jurisdiction without there being a party before it. A DRT passes an order saying that they are determining their rights.
Please, my
So
lord,
this is a fit case to exercise jurisdiction.
then-
So the first issue of going to DRT, no more. Apart from that, what are your submissions?
My
You can
lord,
tell the
matter may
court.
be relegated to DRT fresh, giving an opportunity
My
to the
lord,
petitioner.
Not necessary to tell them.
Then, my lord, that
send
is the
them to
case, my lord,
DRT.
petition has to be, my lord, the borrower has to be before this honorable court, let them take the notice to the borrower because it's not my petition. Borrower filed it, let the borrower before this honorable court, let them file an application for impeding the borrower, let them come before this honorable court, they will assist the court. My lord, if the sale is set aside, tomorrow I'll execute a sale certificate. The order passed by the DRT is set aside by this honorable court. I'll execute a sale certificate in favor of the, my lord, the petitioner.
No, when was the sale?
Sale took place on, my lord, 14/8/2019.
14/8/2019. What is the communication by the bank to the borrower from 14/8/2019 to till the date of 28th February 2023?
The 14/8/2019 is the
You
sale.
took the money and kept quiet. From that time till the order is set aside by the DRT, what did the bank do?
I persuade the matter before the DRT.
So
That's
no
what I can-
communication to
I need
the
not- my lord,
purchaser is not required. You're in position, you are having his money is with you. You don't have to inform him. You don't have to tell him anything.
My lord, here the case, my lord, I given a letter to them saying that, my lord,
Saying?
within, my lord, confirmation of the sale I have given.
You said, I will take the physical position and I will ask you to repay the remaining amount.
My
He has
lord-
been waiting.
My lord, kindly see the paragraph 4 also in this letter, my lord.
Yes.
My lord, letter dated 14/8/2019. Acceptance of the bid of the property so and so, so and so. With reference
With
to
all
that,
this conduct of the bank, I'll say, I'll impose some costs of 2 lakhs on the bank, that shall be paid to him. It will serve the
My
purpose.
lords, there are case laws where damages of 2 lakhs, 4 lakhs, 6 lakhs have been awarded, my lord. Because of bank's lapses, because bank is not responsible to even intimate the auction purchaser, my lords.
auction
I can
purchaser
produce
is-
case laws.
Auction purchases are also, my lord, equally, my lord, he would have verified.
Pass on. Please pass on that. Bank's
My lords-
duty is
my
not
lords-
like a postman and being a mute
My-
spectator.
this is the copy.
Like
It's office copy.
my interest is involved, like how in the other case, like you will take the money from the second successful bidder and then you say, no, I will not issue the sale certificate to him because he is not a successful bidder in the auction. Yes, please read.
My lords, page number 17. In the case of Rakesh Kumar Kaushal versus State of UP,
17 running page or internal page?
internal running page, my lords.
Yes.
17. Right hand side in blue.
Yes.
My lords, in fact, even the jurisdiction was discussed in detail here. Natural justice, in terms of natural justice, under Article 226, there is jurisdiction of the High Court. My lords,
No, you
Further-
don't have to go into the question of jurisdiction now.
All
You're
right.
saying something about the cost.
Damages, my lords,
Yes.
page number 33,
Yes,
paragraph 47.
yes.
In light of the aforesaid discussion, we allow this writ petition with the direction to the respondent bank to refund 60 lakhs, which was deposited by the petitioner being the auction purchaser of the aforesaid property. The petitioner within a period of 1 month, along with interest at 9%, considering the mental trauma and harassment with which the petitioner has suffered during a long period after investing such a huge amount, we impose a cost of rupees 2 lakhs to secure the ends of justice, which shall be paid by the bank to the petitioner within a period of 1 month from the date failing which petitioner will approach the district magistrate, so and so.
Yes. I'll pass orders.
Obliged.
Third resolved.
8 for me.
Cell number 2.
My lords, I'm for the petitioner, my lords.
Yes.
I pray that the liberty may be granted to file a fresh petition in the Harvard court, my lord, and the filed writ petition may be.
Office has taken an objection with regard to the maintainability of the writ petition, as this writ petition can be filed before the it has to be filed before the Harvard bench. Office objection is sustained and the petition is at liberty to petition is at liberty to file the petition before the High Court at Harvard. The registry is directed to return all the papers and the fresh petition shall be filed within a period of 10 days from the date of this receipt of the copy of the order, and for statistical purposes. Yes, next.
Much obliged.
Yes.
VB Ravi Shankar.
My lord, morning, I sought to withdraw the writ petition. My lord, it's a week's time. Now, another update, my lord. It was pointed out that I have not complied with the interim order. My lord, my instructions are today we have transferred a sum of rupees 40 lakhs to the loan account and we are negotiating with the bankers.
Still it is 1 crore.
Well, it's
Amount that is
40 lakhs.
40 lakhs is
earlier.
transferred in lieu of a DRT order passed last 4 days back, where fresh sale notice is under challenge to take advantage, to take liberty, protect their property wherein which auction is
I
conducted.
am not there before
That may not be considered for this case. That's the order of DRT which he has complied.
I am not there before the debt recovery tribunal. My lords, my request is this: 1 week's time, I will approach the debt recovery tribunal. My lords, whatever the condition the debt recovery tribunal imposes, I am ready to comply. And in fact,
No.
my entire
Then
intention is
first of
to
all,
clear
you
the
have
liability.
you cannot ask that before this court because you are enjoying an interim order from the year 2024 without complying it.
My lords, I had partly complied the order. 1 crore was the order which was
Partly
directed
complying the order is not, it doesn't amount to complying the
My
order.
lords, my lords,
The
now
amount that you are supposed to pay by virtue of this interim order is
30%.
1 crore rupees.
1 crore rupees.
How
I
much
had
you
paid
paid?
45 lakhs, my lords.
Not today. That as
I
per
had
this
paid,
order.
my lords. Earlier,
As per this order, how much?
soon
you
after
paid?
the order, I had paid 40 lakhs. my
Yes,
lords.
Mr.
Please show me.
Soon after the order, I had paid 40
For
lakhs.
instructions, how
Have
much
the
is
15
statement
lakhs.
of account.
15 lakhs. In fact,
1.5.
his father appeared before DRT
My
court
lords,
has back.
I-
He agreed before DRT has paid deposit only 15 lakhs.
My lords, I have the statement of account. my lords. I have the statement of account which should go to depict.
Please
my
tell
lords.
the date. You keep the,
Please,
give
my
it to him. Give the order sheet. Yes.
My lords, date of the order is 23/5/2024. my lords. 23/5/2024 is the date of the order.
And when did you, and what was the time stipulated in the said order?
My lords, I had to comply the order within a period of 4 weeks. My lords.
4 weeks.
4 weeks.
So that 4 weeks will, come to an end by 23/6. When was the payment of?
My lords, soon after the order, my lords.
Look, you can give the dates. You have the account.
Please, my lords. On 28/6/2024, my lords. 28/6/2024, I deposited a sum of rupees 3,50,000. Then thereafter, about 6,30,000 rupees, which is deposited on 31/8, my lords. My lords, I agree there is some delay in complying with the
Please don't
interim
tell
order.
that. 3
My
lakhs
lords,
and
my
7
lords,
lakhs amounts
in
to
all-
10 lakhs.
My lords, in
For
all,
an interim order of 1 crore.
my lords, in all, 85 lakhs is paid. If lordships could
No,
kindly.
Mr. Counsel, I will not entertain these kind of writ petitions
My
at
lords,
all, and these
I would
kind of
intend-
rates cannot be entertained.
I would intend to withdraw the writ petition as well.
As it
I would
is,
just
as
seek
it is.
for.
I will not,
I would just seek for liberty to.
liberty I
approach
will
the-
not grant. the petitioner seeks to withdraw the writ petition, dismissed as withdrawn, or the land counsel of the petitioner submits that he may be permitted to withdraw the writ petition with the liberty. This court is not inclined to grant writ petition dismissed as
The merits of the matter.
no, on what ground you are before this court?
Please.
What is outstanding amount?
The outstanding amount according to them, according to the respondent bank, my lords, is 4 crore and 37 lakhs, 37,000.
But that was in the year 2024. Prior to.
No, my lords, my submission before your lordships is not that I had not taken the loan. I have taken the loan. I am under the obligation to make the payment as well. Now, my lords, I am trying to develop an argument before your lordships whether the manner of recovery of loan that is resorted to by the respondent bank stands the scrutiny of law or not. If I am able to persuade your lordships, my lords, only on that limited point, and certainly not, my lords, on the facts of the matter. There is a loan.
What is the procedure adopted?
Very well. Now, my lords, may I request my lords to kindly turn to my lords the loan offer document, which my lords will find at page number 35. Before I take your lordships, my lords, to this loan offer document, my lords, I am a builder, and this loan, my lords, was secured for a purchase of a property in which, my lords, I wanted to conduct my business activity. Now, my lords, the property which I had proposed to purchase out of the amounts which I had secured under this loan transaction, my lords, slipped into litigation for claims, my lords, that were made by the original family members of the original owner. Owing to, my lords, such claims and litigations that this property slipped into, I was unable to, my lords, advance the business for which this loan was taken. Consequently, my lords, the failure on my part to make the repayment, my lords, of the loan that I had taken from the respondent bank. Now, my lords, kindly peruse, my lords, page number 35, which is a loan offer document. Lords will find that, my lords, the type of interest which your lordships will find at, my lords, row number 5, type of interest.
Yes.
Floating rate of interest. So, my lords, it is incumbent upon the bank that the interest that they are levying in relation to, my lords, the outstanding that is there in the loan transaction ought to be, my lords, in terms of the RBI guidelines for floating rate of interest. Now, contrary to this condition, my lords, the rate of interest that is levied now by the bank stands at, my lords, 11.8% as fixed interest.
So,
now, my lords,
admittedly, if according to you, whatever is the interest that has to be levied,
please,
you're ready to pay the money?
Rework the entire calculation and levy, my lords, floating rate of interest. It is my solemn undertaking, my lords, in terms of this document, I am obligated to pay the money. I shall certainly make the payment.
That's the ground.
My lords,
I have provided that particular table. Where is there?
Page number?
Objections could be
You acknowledge it, then you sent you filed an IA also.
Dated? Statement of objections, yes.
Please,
yes.
Internal page para 4. So page 4, in that I have provided a chart, my lord, where there was a variation in the rate of interest that was informed to the petitioner prior to itself because of the changing the guidelines by the
paragraph number?
It's a paragraph under 10, subpara 1.
Please read.
Please. The respondent granted a loan of 3 crores so and so to the petitioner under this particular loan account number. The petitioner was to pay 160 EMIs of rupees 3,72,000 each month, starting from 7/1/2016. The loan was sanctioned in the floating rate of interest, which is based on the floating rate reference rate. The FRR in respect of which is an FRR. The FRR in respect of subject loan between 26/4/2018 to 24/1/2019 varied from 10.5% to 11.3%. So this particular variation is as per the RBI guidelines, which was communicated to the petitioner.
So you have calculated like this. 26/4/2018, it was
10.35%.
6/6/2018, 10.65.
Please, ma'am.
Again, 110, it is 10.11, 10.8.
As per my communication, it is 11.8 and not 10.8.
111, no, that's what they are giving it now. You should have responded to this.
Very well. Well, I just wanted to take your lordships to one more document that, my lords, I place before the hands of the respondent bank before approaching this court. May I just trouble your lordships with just one document, my lords, only to show my bona fides. This is certainly not a writ petition, my lords, for me to evade my obligation. Certainly not, my lords. It's my solemn undertaking. I want to, my lords, service this loan account. I am into this business, my lords, for the last more than a decade. I want to, my lords, maintain my CIBIL score. I want to ensure that my financial credibility is intact. Now, my lords, just permit me to.
It's a good case for you to go before the DRT, where the DRT will take into consideration all these factual aspects, whether all these, the amounts that
Your lordships are aware. Well, that is 17. I'll have to, my lords, make an upfront payment. Now, my lords, my stand before this court.
This court cannot go into all these factual aspects.
I'll just trouble your lordships with only one document, my lords, and then I'm at your lordships' hands. My lords, may I request your lords to kindly turn to, my lords, page number 52, my lords.
Yes.
This is a document or the communication, my lords, that I would place before the hands of the respondent bank on 19th of March 2024. Setting out in detail, my lords, my conduct for non-payment, my lords, of non-servicing of the loan that I had secured at their hands.
Is there any possibility for a one-time settlement?
Lord, that may be.
You can find out.
Very well, my lords. I am, my lords, it is my solemn, my lords, it is an undisputed fact that
It would have been done long back. Why the matter is pending here like this?
My lords, my only request is let them rework the entire calculation. Let them satisfy, my lords, that the calculation that they are relying upon is in terms of the offer document, and let them offer ODS.
The total outstanding, what is being told is that 5 crore 10 lakhs as on today.
5 crore 10 lakhs.
So his limited powers is that if they are ready to pay that particular amount, that can be closed. If at all, the reason is that from the date of filing of the writ petition, absolutely there is no communication. So they have stopped even servicing the loan. Till today, they have not made any payment.
Why there is an interim order in this?
There was an interim order, but
compliance
was also not complied in time. 4 weeks time was granted. They have not even deposited anything. After that, 10 lakhs they deposited. Pursuant to the order of the Honorable Magistrate, they deposited 40 lakhs. So 50 lakhs they have made payment, but after 3 months. So,
that becomes a wrong submission.
Let's not go into it.
Please, very.
Now, what he says is 5 crore 10 lakhs is the payment.
Present outside.
I'll take instructions. Lordships may have it next week. I'll take instructions.
And no further adjournments on the day. Then counsel with the petitioner submits that they're ready to settle. They requested for a one-time settlement. Bank has not come forward. The then counsel appearing for the respondent on instructions submits that the outstanding is 5 crore 10 lakhs. If they're ready to pay the amount, bank is ready for the one-time settlement. It is also the contention of the land counsel, the petitioner, is that when they have given the loan, as per the loan document, it is a floating interest, and now according to him, constantly it was 11.5.
11.8.
11.8. The same is denied by the land counsel, the respondent, and he submits that in his objections it is categorically stated that how, as per the floating interest, as it was varying as per the RBI guidelines, they have they have calculated. List this matter on.
Could it be on 10th, my lord, subject to my lord's
10th of November. No further on the day, if the petitioner is ready for a one-time settlement. If the petitioner is not ready for the one-time settlement, the orders will be passed on the merits of the matter.
I'm so very
Step number 11. Step number 11.
Interim order, my kindly order.
It's not there. That's what you said.
No, my lord, there is an interim order that is subsisting in my favor, and interim order, my lord, has been complied with.
There was a subsequent IA that was filed for the extension of the interim order because that particular order.
What happened to that?
Lord, the order was passed. The first challenge was.
Let's see whether it was subsisting or not. We'll see.
Since there was no compliance, it got expired.
It is on 9/10/2025. It says interim order earlier granted is extended.
Please, my lords. Interim order has been extended from time to time.
It's there in the order. Interim order dated, interim order granted earlier, extended on 9/10/2025, is extended till the next date.
Anyways, fate of this litigation is on 10th.
Huh?
Anyways, fate of this litigation is on 10th. I'm sure my learned friend should not stand on taking it. I'm grateful.
Serial number 11, Krishna S. Vas for petitioner Lokesh KV.
Appearing for the petitioners, my lords.
Yes.
The backdrop of the transaction in the instant case is that, my lords, a loan came to be extended in favor of the petitioner company.
IA number 1 of 24 is filed to dispense with the production of the certified copies of annexure HNK. Dispense with for the present. Yes.
Yes. My lords, in
What is
July
the impugn order?
2021,
First, what is the prayer that is sought in the writ petition?
it is with respect to 13-2 notice, my lords. Quash
What
the
is,
issuance of
what is
writ in
wrong
the
with the 13/2 notice?
Yes, sir. My lords, the transaction here is that, my lords, sir, the amount which has been maintained in the current account of.
Have you, once a 13/2 notice is issued, have you sent your reply to that?
I have not been served with the 13-2 notice appropriately, my lords. I have not been put on notice at all that 13-2 has been served. Only when there was a unsavory exchange of dialogues between the bank authorities as well as myself, my lord, I came to know that this has a small backdrop, my lords. 30 seconds, I will explain it, my lords. Initially, what happened, my lords, is that in the year 2019, this company, my lords, a resolution plan came to be approved with respect to the company. I may draw the attention of this honorable court to the memo which has been filed by me on 28th October 2025, my lords. Along with that, certain documents have been filed by me. That is the amount that I have deposited subsequently and other things, my lords. Have your lordships got it, my lords? 28 October 2025, my lords. That is yesterday. An additional copy is here, my lords. I can.
I have it.
Yes, please.
Yes.
I draw the attention to page number 4 of that memo. The instant company, my lords, has already been, a resolution has been passed. Wherein, my lords, a resolution applicant has been asked to take over the company on 10th May 2019 itself. And subsequent to the resolution order having been passed, my lords, there was an appeal which was preferred by one of the other resolution applicants, my lords, which is pending before the NCLAT, my lords, at New Delhi, which is at page number 27 of the same memorandum, my lords, wherein an order has been passed that finally the matter has been posted for disposal, my lords, whether the resolution applicant, whatever resolution order has been passed, whether it has to get through or not. In the interim, my lords, I was called upon by the bank authorities themselves, my lords, to get a loan from them for about 9.5 crores because I had to operate the things. This instant property has already been mortgaged with Karnataka Bank, my lords, in spite of which there was an offer made by the bank asking them me to take a loan from them, and I had submitted with them for taking of the loan because 9.5 crores it would be utilized for my capital seed funding and I could run the business.
Who is the respondent?
Respondent is Sri Charan Cooperative Bank, my lords, who is not even a part of the COC, Consortium of Creditors. Now the question here is that, my lords, in spite of knowing the entire fact that
did not mortgage any property to them.
That is where, my lords. Now what happened was a simple mortgage came to be executed from me with respect to this property, my lords, which is already a part and parcel of the resolution plan. All these aspects why I am bringing to the honorable court is not to cheat the bank. It is not to cheat the bank, my lords. Just I will put across my aspects, my lords. Here, after the mortgage deed came to be executed, it is only for the sake of my convenience that I had borrowed the loan. Originally, they had said that there would be an amount of about 9.5 crores which would be dispersed to me, whereas only 6 crores came to be dispersed to me. That also is a matter of record, my lords. Out of that 6 crores, a huge amount of money came to be transferred to one Sri Charan Sauharda Society, my lords, stating that you had to become a member of that society for availing the benefit with this cooperative bank, which also I obliged. Then later, my lords, they said that they would be transferring the remaining amount of about 3.5 crores after a period of time, but they never did that. But subsequently, my lords, the checks which had been received from me, my lords, from my current account, my lords, spurious cash withdrawals have been made by the bank themselves, not to a small amount, my lords, but to a huge extent of money. The question is that, why did I keep quiet for all the while? It was not that I kept quiet, my lords. No account statement was given to me at all. Whenever I was asking the bank.
You and bank were doing so many things
Yes.
with your own understanding,
Yes, please,
which cannot withstand the scrutiny of law.
Yeah,
So why should we look into it in a writ petition?
The only aspect what I want to canvass before this honorable court is that, my lords,
Your lordships may see the current account statements, my
No,
lords,
you
what is
say a
contained.
property which is already mortgaged
Yes,
to Karnataka Bank.
Yes, please,
Which is known to this bank.
yes, please, my lord.
And both of you, again, another some nominal mortgage is executed.
Yes, please, my lord.
Money is taken.
Yes, please, my lords.
And
Money is taken, but
and for that,
I have.
you complain about an irregularity in that.
No.
In any of the subsequent proceedings initiated by them.
My lords, the party should be guilty of that aspect, that he should not have entered into a mortgage with respect to this. I have no reservations
When there are no
on that.
bona
He
fides
should
on the
plead
part
guilty.
of your client, but when you wanted a public money of 9-10 crores without even a mortgage, and you and the bank officials have colluded, now that collusion let both of you carry on. Court will not interfere with that.
No, my lord. So only one aspect I want to canvass. Your lordships, if you are not convinced, I don't want to stand in the way, my lords, because I want to bring every aspect to the notice of this honorable court. That is all my intention.
Because your client is not entitled for any relief from this court because your intentions right from the beginning are not correct. You have come to the court with clean hands.
My lords, that is
I mean,
not the
new
issue.
argument, no Karnataka, no pleadings, no, I'm not aware, my lords. It's absolutely new circumstances.
Your lordships,
Karnataka,
No, your bank will know.
no, bank is also not aware.
Hand in glove.
You should have told
They
it.
say that which is
Let him show.
encumbrance, they say that I do not
No,
know
no.
the loan at all.
He has executed a mortgage deed where he says the property is free from all the encumbrances, and kindly look into in pleading. This what all he's telling is a fresh no pleadings.
My lord, sir.
No pleadings
I
at
draw the
Karnataka
attention
Bank.
of this
We'll file a
honorable
criminal
court.
complaint against him. That is the case. If he
Please
has
do
not,
that.
Let them
we'll
do that.
absolutely will do it.
Let them do
Also
that.
And
do
kindly,
against
kindly come to page 51, my lord. Page 51 may kindly be looked into. After the issue demand notice, he gives me this letter, states that please I'm in problem. Page 51, annexure J, which he himself has produced. And now he comes and telling all of frivolous stories, telling that it's mortgage in Karnataka Bank and resolution of 2018. I don't know in what way it will be of help to him.
Lords, the question here is that, my lord, sir.
Let me
Party is
finish.
working out for your
Page-
aspect has not yet
page
come, sir.
51.
I have not yet completed.
Page 51 may kindly look into.
My lord, sir.
His own letter.
My submission before the court is that we want to settle the entire claim, my lord, sir, of the bank. It is not that because we have certain loopholes in the entire case, we want to dodge them. That is not our issue. And more particularly, my lord, sir, when the bank has already the property which has been mortgaged with the bank is already a subject matter of resolution. However, they cannot proceed with the DRT proceedings or SARFAESI proceedings. My only intention is to ensure that, my lord, sir, yes, a soft closure is brought to the
Part
case.
of the resolution proceedings, which is mortgage via Karnataka.
Karnataka Bank. So it is already a part and parcel of the resolution
So
proceeding.
now we will not interfere in this petition because
Yes, please.
a property which is already mortgaged to Karnataka Bank, you have again mortgaged it to this bank and obtained a loan. So what they can't do, they cannot do. So why you require an order from this court?
What your lordships are saying is absolutely correct, my lords. But only one aspect that is that, my lords, a soft closure to the matter has to be brought on record, my lords. Therefore, they have waited for all along.
You please
And
use your
an interim order of this honorable court, my
let
lords,
your client use his good officers as already he's been doing it.
that has not been done, my lords. In fact, interim order of this honorable court prescribed me
case,
to
interim order
deposit.
is
Yes,
granted.
yes. Prescribed me to deposit about 20%. Over and above which, my lords, I have deposited about 30% of the amount, my lords, in the interregnum. My only intention is that, my lords,
I will not pass any order.
if
No indulgence at all.
if the matter is kept in abeyance for some more time, my lords, there is a possibility that, my lords, the resolution plan may get through. Once it gets through, my lords, the entire amount of money what is supposed to be received by the respondent, he will immediately receive it. In the event that, my lords, that does not get
How
through,
much you will pay to the Karnataka Bank? How will you pay to this bank?
all the money whatever I have received from them, according to the
And
last
what
5,
about
my lords, I will
Karnataka
be
Bank?
paying it up. Karnataka Bank is already part and parcel of the resolution plan, my lords. They will take the money from the resolution plan which has been already been approved. They are taking to an extent of about 130 crores is supposed to be given to the Karnataka Bank, which they will take it from the resolution plan, my lords. Only aspect is that.
I'm asking you, what is your apprehension? Now, you have a property which is and according to you, the property now it is part of the resolution.
Yes, please.
They cannot go against it.
Yes, please.
So why should we interfere in all this?
It is only the question of reputation of the honorable court. What he seeks before this honorable court is, my lords, if the matter is kept in abeyance for some more time, my lords, because since from 2024, I have not tried to evade any payment to the bank. Rather, the interim order of this honorable court states that about 20% to be deposited. I have deposited more than that. In spite of the matter having been brought to the honorable court in the interim, my lords. My intention is to ensure that a smooth closure of the matter is brought about in the picture. Let them speak to their respondent bank also, my lord.
Very unfortunate that.
I have instructions, my lords, no such proposal.
These type of matters, High Court is, before the High Court, these type of matters are settled.
May I make one submission, lords? Kindly look into the resolution plan.
There is
The
no
fraudulent
other
part of the borrower will reopen now. 2018 or 19 order, he mortgaged the property in 2021.
That is what I'm saying. That is what I'm saying.
After that,
Already
he has not even
resolution
disclosed to me that
passed.
there's a resolution plan already there.
Come. The present writ petition is filed with the following prayer. I will not record all that you have said. It will
please,
be
madam.
unnecessary.
Yes,
It will
please.
it will go against your client.
I know that, my lord.
The writ
I
petition
can
is filed
understand.
with the following prayer. Then council has submitted that the notice is not served on him. And as such, he could not he could not submit his objections under section 13(3)(a). What is the present stage?
Present stage is, in fact, 13(2) and 13(4) both are under challenge in this writ petition.
Even as
Both are under challenge.
even as an
13(4)
interim order is operative from
We'll
this
proceed
honorable
further,
court.
minutes. We'll proceed further amongst the filing section 14.
So-
Anyway, we have further cause of
Yes,
action to challenge.
There is no opportunity for him to submit his objections. This court has perused the grounds and heard the argument of the learned counsel for the petitioner. When the 13(4) notice was already issued to the petitioner, he has an effective remedy of approaching the, he had an effective remedy to approach the DRT. And all the issues that are raised before this court cannot be considered in the light of the settled law. And this court finds no reasons to interfere. Accordingly, the writ petition is dismissed,
Obliged.
giving liberty to the petitioner to avail the appropriate remedy,
Obliged.
if it is in accordance with law.
Obliged.
My lords, interim order, my lords, in the meanwhile, for a certain period of time may be continued, my lords. I will approach the DRT in the meanwhile.
Yes, next.
Cell number 22.
Yes.
Vignesh Shetty.
Lord, senior counsel lecturer in this matter, my lord, is having an appointment at 4:30.
Tomorrow, next.
Kindly have it tomorrow.
Next.
Cell number, list number 3, serial number 1.
Give the file.
I'm sorry, my lords.
We'll take it up tomorrow. There's so many other matters are there today. Yes. The,
Pardon.
the matter, as there was no representation on 27/10/2025, the matter was directed to be listed today, listed on 28/10/2025, and the caption for dismissal. And the matter has reached in the pagan, though there was no representation, again giving an opportunity to the petitioner. The matter is listed again directed to be listed today under the caption for dismissal. In the forenoon as well as in the afternoon, there is no representation on behalf of the petition. Accordingly, dismissed for non-prosecution. Yes.
Cell number 4.
Yes.
Cell number 4. Here is Parshuram.
You appear?
Serial number 4, list number 1. Reach here.
This is not the MFA list. Notice to the respondent. Next.
Cell number 10.
Yes.
Cell number 10.
Lord, I'm told the application seeking stay has reached the court, my lord.
What is the amount that is granted?
Lord, in complete disregard to the every statutory requirement under section 125, my
Not
lord.
going to all that now.
No, my
First, for a stay.
No, the reason is that, my lord, wife is working as a lecturer and the wife has made the husband to resign from the job, saying that we will start oil extraction business. And she herself has deserted the husband. And it is the husband who is the victim in this marriage, my lord. And she suppresses all these things.
All these aspects we'll consider once the wife enters into it.
For a moment, my lord, kindly see just one paragraph, my lord, of the impugned judgment, my lord.
What is the amount granted?
Lord, 7,000 rupees, my lord. He is working as a coolie, and where she is a lecturer, my lord. She is a guest lecturer in the government law college, government degree college, and she draws a salary of around 32,000 to 35,000 every month, my
Evidence
lord.
is there on record.
Yes, my lord, it is there on record, my lord. Lordship, and kindly see
What is read paragraph number 44?
Lord, kindly see the reasoning, my lord. Lord, para number 19, my lord. Page number 35 of my compilation, my lord. The petitioner, in her evidence, has asserted that she has no independent source of income to maintain herself, and her parents are poor, and they are not in a position to maintain herself. This is what she states in her application. Interim application is dismissed, and subsequently, my lord, when the evidence commences, I produce her salary slip, and then, my lord, from para number
7,000 maintenance to the wife. The husband is working as a coolie, whereas even as per the order of the court, she's working as a guest lecturer. It is submitted that the meager income he is getting, it's difficult for the husband to pay the amount. It is pay the amount considering the same. They shall be stay of all further proceeding. So and so, notice to respondent. Pursuant to the order dated so and so. Yes.
List number 4. For orders matters, CL number 1.
Memo is filed seeking dispensation of notice to R1 dispensed with. I number 1 of 24 to condone the delay of 126 days. Condone. It can be heard.
Call for TCR, madam.
TCR is required.
It can be heard immediately after.
126 days on condition. Admit. Post for final hearing. Call for the TCR next.
CL number 2. Raghu R.
I am for respond number 2, madam.
In this case, R1 may be dispensed.
Memo is filed seeking dispensation of notice to R1 dispensed with. IA 1 of 24 66 days. Condone.
Meanwhile, call for TCR. Paraplegia case, madam.
Admit. Post for final hearing. Call for TCR.
CL number 3. Rosa Paramel.
Memo is filed seeking dispensation of notice to R1 and R2.
My lordship, I am appearing for the appellant. We have filed a memo seeking dispensation of notice to R1 and R2. Even in
post for final, it can be heard.
We have given the offer for 1,20,000.
Yes, they are given the offer for 1,20,000. Is it acceptable? Rosa Paramel.
Hello, sir. Rosa Paramel.
Lady.
Admit post all for this also fourth. Admit post for final hearing. Call for the TCR list on fourth. Yes, next.
CL number 3. 4.
I am for applying my lordship. Steps to be taken. R1 is
Steps. A week's time. A default order against R1.
CL number
4.
5.
5.
I am for applying my behalf of Ravi Sampriti. I am representing my behalf of company name has been changed. I am filing the memo for along with certified copy. Company name has been changed. Sir, what up, sir? Insurance company challenging on the ground of quantum, my lord. Case of death, my lord.
What is the name of the company change? Royal Sundaram General Insurance.
Please, my lord. Royal Sundaram General Insurance.
Before the trial court, what is the name?
Trial court, my lordship. Royal Sundaram General Insurance Company.
Then what is the change? The Royal Sundaram General Insurance before this court.
Royal Sundaram Alliance General Insurance Company before
Now
tribunal,
it
my
is
lord.
changed.
Now we change Royal Sundaram General Insurance. Company was original incorporated with name of the Royal.
First of all, whatever is the name, earlier name, it should be there. Then you should say, as per so and so, the company's name is changed. So I may be permission to amend the cost
Please,
title.
ma'am.
Without that, if you give a memo like that, what I should do? It is submitted that the name of the insurance company is changed. The petition shall come up with appropriate application.
Please, ma'am.
Yes. When do you want?
Weeks time,
A
ma'am.
week's time. Yes, next 6.
CL number 6. Maintainability.
Yes.
Right, in this case, the award amount is less than 1 lakh. Right? We are challenging the liability. Therefore, our appeal
The
is
ground
maintained. The Disamba court
On the ground that?
limited, barred by limitation. That is the, as per the new amendment, Malat, they have to file a claim
The
petition.
office has raised the objection with regard to the maintainability as the awarded amount is less than 1 lakh.
Less than 1 lakh.
1 lakh land council submits are they're questioning. They are before this court on the ground of maintainability. and the same is maintainable. Accordingly, the office objections are overruled. Notice to the respondent.
Similar matter, my lord.
Then non-compliant office objection shall be complied with.
Please.
Then 7 also same.
Please.
7 also same
7
order.
is also sought
Notice
for
to the-
stay of the proceeding in that. Ma'am. So,
There is no stay petition here.
application is filed, ma'am. It is
Look at it.
7, 8 and 34.
In 6 also it is there.
Please, ma'am. 6 and 40.
In 6 also, stay on the condition that 50% of the amount shall be deposited within 4 weeks. Then 7, same order,
Please.
stay on the same condition.
Arise 54.
8 also same.
54 is also connected to that.
Then in 8, office objections to be complied of each
Right.
time default order. Then
Please.
9,
Till number 9.
what about 9? Objection, acknowledgement for serving the copy.
But in this case, my lord, what the amendment, after the amendment, they have filed a claim petition on 164, on the section 164 of the Motor Vehicle Act, where, my lord, the only one vehicle is involved. For his own negligence, he cannot maintain a claim petition. Without considering, court has awarded.
No. What is this council submission, office objection? Acknowledgement for having.
We have served the appeal memo through mail.
Oh.
That is the office submission.
Who is-
Non-servicing of. We have sent the appeal memo through mail
Where
to
is
the
this
advocate.
Where is this council?
He has not appeared before this court. ma'am. But what has happened? We filed a miscellaneous petition before the MSCT. They have taken the warrant against the insurance company. They have not appeared before this.
Stay is not there.
That is the reason, my lord. We sought for stay of the proceeding.
How much is the
he
amount?
will- But 12 lakh, we are not liable to pay any amount, my lord, in this case. Only one vehicle is involved. For his own negligence, he cannot maintain a claim petition on.
The office has taken objection with regard to serving out the copies on the caveator. It is submitted that they have already served the copies through WhatsApp.
Mail.
Through mail. Through mail, they have served the copies. It is submitted that the claimant, who himself is a tortfeasor, is not entitled for any compensation under section 164 of the Act. Considering the same, there shall be stay of all further proceedings pursuant to the so and so on the condition that you are depositing how much, 50% or 100%?
50%. I'm not liable to pay any amount, my lord. I will deposit before this court. If the
On the condition of depositing 50% of the amount
before this court.
within 4 weeks. Yes, next.
On deposit, it may be kept in FD, my lord. So
The deposit shall be on such deposit, the amount shall be kept in FD.
much.
Yes.
Till number 10.
So there are no other respondents.
Which one?
No other respondents in 9.
The owner of the vehicle is also there.
Notice to which respondent he is.
R1
Two
is
minutes.
stay with her, 2.
Notice to respondent number 2. Yes, 10.
Till number 10.
93 days
Delay of 193 days, condoned on condition, admit post for final hearing.
It
Any
can-
matters where you are ready,
It can be disposed, but they are not entitled to get under any of the
list is matter on
heads.
4th. Yes. 11.
Till number 11.
Fine number 1 of 24 to condone the delay of 388 days, condoned on condition. Admit post for final hearing TCR.
Till number 12.
For respondent.
Once the delay is condoned, I don't have to tell. Admit post for final hearing TCR. Yes.
Till number 12.
12 also appear. 82 days delay condoned. Same admit. Yes.
Till number 13.
13, my lord.
Jai Kumar Adil.
Huh?
There is a delay up to 26 days. It's only claimant's appeal. For quantum, they are also come up with some amount. We are settled that amount. 85,000.
We'll have it on 4th. In between, you can settle it.
It's already it's there.
Okay,
Already
fine.
settled. 85,000. They are all part.
Agreed 85,000.
85,000.
in addition.
Global.
Nature of injury, additional compensation of 80,000. 85,000.
No,
In
it's
addition to the 1,50,000.
order or Lok Adalat?
No, my lord. Judicial order.
That we will, then end of the list I'll take.
Please.
Yes, this end of the list. Next 14.
Till number 14.
Notice to the respondents.
Corporation murder.
Huh?
Appeal by corporation. Case of injury murder.
What is the compensation? How much is granted?
4,22,942 murder.
4,22,000. You are on the ground of
On negligence murder.
negligence.
He was
So deposit 3 lakhs.
Here, my lord,
The insurance company, then counsel for the,
50%, my lord, will deposit.
no, more than the 50%. Then counsel
Here,
for the.
here, my lord, he had slept the, my lord, below the bus stand in the bus stand in the.
Counsel for the appellant submits that there is a contributory negligence on the part of the claimant which was not considered by the court. Considering the same, they shall be stay of all for their proceedings. 50%. On such deposit, they are entitled to withdraw notice to the respondent.
Cell number 15, Sachin Ray London.
Until there is a delay, my lord, I do not take.
Some 41 days delay condoned on condition, admit fund layering TCR. Are you ready with
Claimant's
this?
appeal, I can next date. I'll do it.
Fourth,
Fourth
lift
month.
the matter on fourth. Yes,
Cell
16.
number 16, Renuka HR.
In this case, challenging the quantum of compensation.
How much is
As per
awarded?
the injury, my lord, lacerated wounds, 3
Now, how
lacerated.
much is awarded?
4 lakh is awarded for a lacerated of 3 lacerated wound. They are not entitled to get not even 25,000 rupees of the award. Still court has awarded.
Calls for the petitioner, appellant submits that the petitioner, the appellant, the claimant had sustained lacerated wounds. The court had granted 4 lakh compensation. Considering the submission, they shall be stay of all further proceedings on the condition that they should deposit 50% of the amount. In this, no withdrawal. Notice to the respondent. Yes,
Cell
16.
number 17,
17.
For insurance.
Krishna Kishore.
We are challenging the liability in this case where the claimant himself is the insured in this matter. He's claiming under 166. He's not the third party in this matter, my lord. And also, even though if the PA is covered under his, it has to go back to the state commissioner, not before.
The insured himself is the claimant and is not entitled for any compensation. The court, without considering this aspect, has granted the compensation. Say 50%. In this also, no withdrawal.
Cell number
Notice to the
18,
respondents.
cell number 18,
Yes.
Filed this petition with an intention for enhancement, but by oversight, there is a mistake in the prayer where I have asked for set aside and quashing away of the judgment dated before this thing. I may be permitted to amend that prayer, my lord.
Petition is permitted to amend the prayer.
Same in serial number 20 as well.
20.
R2 is HDFC, R3 is KCL.
No, let him amend the prayer, then we'll.
But 20 as well, same.
Cell number 19, FS Dabali. 19.
19. Case of injury, murder, both on the point of negligence as well as the quantum,
Negligence and quantum.
as well as the quantum. Lord.
How much is awarded?
Here 9,71,000 has been awarded.
It is submitted to the insurance companies and the question of negligence and quantum. The consider the submission 50% withdrawal. Notice. Yes, next.
20,
As well,
Omkar KB.
Notice which
It's
is
same, my lord.
same. 20 is over. Is
18 and
21.
20 HDFC.
Now 18 and 20 are one and the same.
Oh.
Yes, 21
Cell number 21,
An insurance company appeal challenging the liability.
on the ground.
Negligence. The accident occurs between a tempo traveler and a lorry. The initial record, the FIR will be filed on the driver of lorry bearing. Even the claimant also gives the evidence against the lorry driver. But the owner of the lorry, being a local, he manages the jurisdiction police and files a charge sheet against the
So very complicated case. How much is granted?
3 lakh 25.
Say 3 lakhs. It is submitted if the involvement of the vehicle is in question. They shall be stay half permitted to withdraw. To notice to the respondent.
cell
Yes,
number
next.
22,
What is this? What are these delays, Mr. Dabali, in every
Because
case?
matter, there is batch of claim petition matter of 30 cases.
What about this?
The claimant has also filed matter. This is connected with not 24.1, which is 24.1 matter.
No, we are at 22.
It is connected with the claimant subject 24.1 matter.
24 point?
1 matter. 61.
It is connected for 24.1, my lord.
Hmm. No.
But
How
wherever,
is 22
wherever my
connected?
name is there, wherever my
Same
name,
award, same award, one by the claimant and another by the corporation.
No, your corporation appeal is there 24.
Serial number 22, matter.
22. Corporation appeal is there at 24. Again.
No, 24.1, matter. 24.1.
In earlier case, my lord, lordship granted stay for 50% and
Insurance company has filed MFA 4950 of 2025 and the claimants have filed MFA 6182 of 2024. In the other matters, this court has already granted stay on the condition of 50% of the on deposit of 50% of the amount on such deposit. The respondents are entitled to withdraw the amount.
M.I. Srinivasan may be directed to take notice
Yes,
madam,
Mr.
for respondent number 1.
Yes,
Respondent number 3 is my insurance company.
Why is directed to take notice on behalf of respondent number?
1 madam.
2 is?
2 madam, notice has to be issued. The owner of the under there is
Yes,
one.
two notice.
And third madam, respondent in the connected matter.
Huh?
Insurance company. For third
Mr. What is his
respondent.
name? S.V. Hegde Moolkan is directed to take notice on behalf of the third respondent.
Third respondent.
Yes, notice to second respondent. What about
respondent number 1 permitted to withdraw the amount, my lord.
23 madam.
Respondent number 1 permitted to withdraw the amount, my lord.
Oh, that I already said. Yes.
23 madam, there is also connected appeal madam filed by the claimant. This is connected with earlier matter,
And where is the claimant's appeal?
which has not been listed.
So 23, see,
23.
50% on such deposit they are entitled to withdraw.
And M.I. Srinivasan may be
Mr. Srinivas is directed, M.Y. Srinivasan.
for R1.
Srinivasan M.Y. is directed to take notice on behalf of R1, same R3A.
R3 madam.
R3 same and R2 notice.
Notice.
Yes, 24.
Number 24.
This also same.
This is connected with my 24.2 by the claimant appeal.
MFA number 49944 of 2025 is filed by the insurance company and against the same award, the claimants have filed MFA 6194 of 2024. This also, Mrs. Srinivas and all, 50% entitled to withdraw. Yes, next.
For claimant madam, Srinivasan may be directed.
I said that it's done. Yes, next.
Cell number 25.
Yes, Mr. Tabali. What about this? This also same?
Case of death madam.
How much is awarded?
23 lakh 10,000 has been awarded.
23 lakhs?
10,000 awarded.
According to you, how much it should be?
We will deposit more 50% more.
Not 50% in these death matters. According to you, what is wrong with the calculation, you tell, and that we will ask you to deposit.
Because on the point of negligence as well as the quantum, we have filed this appeal.
Deposit 16 lakhs. The appellant shall deposit. It is submitted that the court had failed to consider the contributory negligence on the part of the deceased, and the amount of compensation that is awarded by the tribunal is on the higher side. The appellant shall deposit an amount of rupees 16 lakhs, and on such deposit, the insurance within 4 weeks. In all these matters, 4 weeks, and on such deposit, the respondents are at liberty to withdraw notice to the respondents. Next 26.
In terms of award, there are minors. In terms of award,
they are permitted to withdraw as per the conditions laid down in the award.
Cell number 26.
Yes.
26 blood. This appeal is filed by the owner of the bus. Notice may be ordered, my lord.
Notice to the respondent.
Cell number 27.
I'm appealing for the appellant, my lordship. My lordship, is a collusion between the bus as well as the lorry, my lordship. For bus policy lab prior the accident, and a premium paid through the check, my lordship, 28/3/2018, and check was same day. It was letter sent to the RTO officer as well as the owner of the bus. So accident occurred in 25/2018, my lordship. We challenge the liability.
Whether it is in the notice of that person.
Yes, my lordship.
How?
We have exhibit, my lordship. Exhibit.
What is an acknowledgement?
My lordship.
Acknowledgement.
Everything is there in a trial court record, my lordship. Exhibit R2 to R9.
What is that? You have the order. What is that? Exhibit R2 to R3. Give that to file.
27.
27. Which MVC is this?
This MVC is 423 of 2019, my lordship. Sorry, my lordship. Is a 30 of 2020, Jyoti.
Certificate.
R2 is the policy copy. R3 is bank receipt. R4 is notarized check copy. R5 and R6 check bounce letter. R7 is postal receipt. R8 notarized
Postal
copy of
receipt is
acknowledgement.
dated?
Premium paid on 28/3/2018.
No, postal receipt is dated.
5/4/2018.
No, it is postal receipt. You don't notarize copy of the acknowledgement. Exhibit R8 is also there. Yes.
Yes, ma'am.
Then counsel for the petitioner submits that. As on the day, the accident has, appellant submits that as on the day. There was no policy and the insurance company is not liable to pay the compensation. All these aspects are not considered by the court. Considering the submission, 50%, no withdrawal permission, notice.
28 also same thing, my lordship. 28 also same.
This also same, no withdrawal. Yes, 29.
Much obliged, my lordship.
29 Mala, KSRTC fees, overall 31,39,000 has been awarded.
31 lakh?
39,000.
It's a case of death.
Yes, death,
You are
my
on
lord.
what ground?
Contributory negligence and quantum. My lord, there is a valid case. In fact, we will deposit 16,39,000 along with
Deposit
interest.
20 lakhs. 20, it is submitted.
No. We contributory negligence, 50% of negligence. In fact, we have reduced that.
Court, in a case of death, court will never say
Then let
50%.
them withdraw only to the extent of 16,39,000. Then rest of the amount let that be.
The insurance company, it is submitted that there is a contributory negligence on behalf of the deceased and same is not appreciated with the trial. They shall receive fall for the proceedings on the condition that they shall deposit an amount of rupees 20 lakhs. 20 lakhs and the respondents are at liberty to withdraw an amount of rupees
16 lakh 39,000.
as per the 16 lakhs as per the conditions laid down in the award. Yes, next notice.
Rest of the amount let that be.
Yes, next.
Cell number 30.
My lord, I am for appellant claimant's appeal for enhancement. I filed memo for dispensation of notice to R1. R2 is the United India.
Dispensation of notice to R1. Who is R2?
United, my lord.
Mr. L. Srikantra is directed to take notice on behalf of the respondent insurance company and land counsel for the appellant to serve the copy of the appeal memo. IA number 1 of 25, 91 days condoned, admit Pandey in PCR. Yes.
31.
My lord, advocate's name, my lord, actually it is not heard.
L. Srikanth Rao.
Advocate insurance.
L. Srikanth Rao. Yes.
Much.
Cell number 31.
Appearing for appellant.
New India Assurance.
Who are the respondent? Which is the respondent?
New India Assurance is R2. R1. R2 is New India Assurance.
R1 is private part.
Private person.
HR Renuka is directed to take notice on behalf of the respondent insurance company. Notice to R1.
There is a delay of 153 days.
Huh?
There is a delay of 153 days.
Delay no, it will not be condoned now. Notice should be served on the other side. Yes.
Cell number 32. B. Pradeep.
Delay of 3 days condoned.
Notice may be dispensed to the
A memo is filed.
2 to 4.
Notice to?
Matter may be referred to Loka.
Notice to?
2 to 4.
2 to 4. At the request of the parties, the matter is referred to the local Adalat.
My lord, I have filed the wakalat. My lord, kindly wakalat may be accepted. My lord.
Wakalat filed on behalf of respondent number
1.
One claimant is accepted. 33.
Delay.
It's condoned. Yes, next
Cell
33.
number 33. R2 Tata AIG. Girish R. Ganesh R for appellant.
Mr. Janathan Reddy is directed to take notice on behalf of the insurance company. Notice to R1.
1.
Notice to R1. Next 34.
R2 is court of York.
Mr. P.S. Jagdish is directed to take notice on behalf of the respondent insurance company. Notice to respondent number?
R1.
R1, yes, 35.
Cell number 35.
Yes.
R2
Which
is
is-
HDFC Ergo.
Huh?
HDFC Ergo.
Mr. B.C. Sivanagowda is directed to take notice on behalf of the insurance company. Notice to R2,
R1.
R1, yes,
Cell number 36.
Appear to the appellant in
Tata
this case,
AIG.
kindly dispensation of notice to R1, my lord.
memo is filed, seeking dispensation of
R2 is
notice
the
to R1.
Tata
R2 is
Tata AG.
Tata AIG.
Tata AIG. Mr. Hegde Mulkand is directed to take notice.
Cell number 37.
Delay of IA number 1025 is filed to condone the delay of 74 days. Condone, admit filing TCR.
Cell
Yes.
number 37.
Appear for the appellant in this case, my lord. Memo for dispensation of notice to
File
R1.
seeking dispensation of notice, which is insurance company.
Tata AG, my
Tata
lord.
AIG.
Same in this matter also,
Please.
same advocate. Yes.
Delay
Yes,
of
sir.
what?
Delay of 269 days condoned on condition. Yes, 38.
Cell number 38. R2 ICICI number.
Mr. Ashok and Patil is directed to take notice on behalf of the insurance company. Notice to
R1.
R.
R1.
Yes.
Cell number 39.
Case also, my lord. Respondent, sole respondent, only one respondent.
Case artist.
Please, ma'am.
Mr. Dabali is directed to take notice on behalf of the insurance of the respondent case RTC. IA number 1 of 25 to condone the delay of 411 days. Condoned on condition. Yes.
Cell number 40. R2 SBI General.
What is that?
SBI General Insurance Company.
SBI.
SBI.
What is that insurance company?
SBI General.
SBI General Insurance Company.
Pradeep takes note. For the respondent insurance company, Mr. Pradeep is directed to take notice. Notice to R2,
R1.
R1. Yes.
41. D. Vijay Kumar.
On behalf of D. Vijay Kumar, representing my insurance company, challenging on the ground of negligence as well as quantum malady. Case of death, my lord. Connected matter also granted stay malediction.
How much is the amount?
22 lakhs 62,400 rupees.
Death case.
Death case.
62,000.
22 lakhs 62,400.
22 lakhs 62,000. It is submitted that it's a case of death and there is a contributory negligence and the quantum that is awarded by the tribunal is on the higher side. Considering the same, there shall be stay of all further proceedings on the condition that they should deposit 15 lakhs rupees and on such deposit, the respondents are at liberty to withdraw as per the conditions laid down in the award and this amount within 4 weeks. Yes.
Call along with 5685
List along with so and so. Notice to the respondent. Yes, 42.
Cell number 42.
Srinivasan MY.
Srinivasan MY. R2 is Magma.
In this case, my lord, SV Hegde Mulkund filed appeal, my lord, respond number 2, my lord.
Sri Hegde Mulkand is directed to take notice and list this matter along with
My lord, 7880 of 25.
you understood what it is? Yes. Yes.
Notice to R1.
No. Notice to R1.
Cell number 43.
Appealing for the appellate, my lord. Claimants appeal for enhancement, my lord.
Which is the respondent?
R2 Universal Sompo.
Universal?
Sompo General.
Sharanappa Gowda Mali Patil. KPS? He comes to the court.
Chanappagoda Mali Patil.
Sharanappa Gowda Mali Patil is directed to take notice on behalf of the respondent insurance company. Notice to R2.
R1.
R1.
Sir.
Liabilities on whom?
Respondent number 2, my lord.
Insurance company.
Yes, ma'am.
Then why don't you give a memo for dispensation?
I will file.
Yes, a memo is a memo for dispensation of notice to R1. Dispense with I number 1025 to condone the delay of 17 days condone. In all these matters, wherever the advocates are directed to take, in all that you write that a copy of the appeal memo shall be served on them. Yes, next.
So for admission matter, cell number 44, Gopal Krishna.
Paper appellant, kindly call for trial court records మీద
Yes, admit post of final hearing, call for the DCR.
Number
Next,
45.
Ravishankar Shastri. This can be disposed of? Huh?
Ma'am.
End
No,
of the
ma'am.
list. Not end of the list, we'll take it up on fourth.
Ma'am. 411.
Fourth, yes.
Till number
This is matter on
46.
fourth, 46.
Till number 46.
For the
P. Vijay Kumar.
cross objector, this is the case of death, my lord.
We'll take it up on fourth. Yes, admit, list this matter on fourth.
Till number 47.
7, it's by owner's appeal.
Huh?
There are other connected matters.
Hmm.
Same accident. Liability has challenged. But,
Huh.
notice R2 insurance.
Notice
New
to,
India.
notice to respondent.
R2 New
List,
India.
list along with so-and-so. It's 48.
Your Lordship, insurance company is in appeal challenging liability on the ground of involvement of the vehicle, Your Lordship. In this case, owner also has contested. He has got his driver also examined. At the time of accident, that vehicle was at some other place. They have given all the details to the police also. Police, after examining the vehicle, they have left it without seizure and all. After 8 months, they again file a charge sheet. He has, owner has filed a PCR also against that before the magistrate court, Your Lordship.
She submitted the involvement of vehicle is questioned by the insurance company before this court. Questioning this question, the stay of all further proceedings on the condition of 50%, no withdrawal notice.
Your Lordship, it may kindly be ordered to be listed along with the MFA 3156 of 25.
Along with so-and-so. Is 49.
Till number 49.
Appeal by the case of death murder.
Hmm?
Case of death murder, appeal by the.
How much amount?
On the point of
How much amount is how much?
25 lakh and onward.
25 lakhs, yes. On what ground you are?
Negligence, madam, on the point of negligence.
Yes, 16 lakhs entitled to withdraw as per the award for 4 weeks. Yes,
50
next notice.
Stay money, 50%,
16 lakhs,
15 lakh.
16. Yes, next.
Till number 51.
50.
50. P. Pradeep.
Please, insurance company appeal challenging the liability. That maintainability they have filed. The tribunal has awarded 1 lakh. I am challenging the liability on the ground that they barred by a limitation 6 months. Therefore,
Submitted that the appellant insurance company is before this court questioning the liability on the ground that it's barred by the claim petition is barred by limitation. Stay 50%, no withdrawal. Notice to the respondent. Yes, 51.
Owner's appeal, my lord. Liability has been fastened on me. 13 lakhs 30, my lord.
On the ground?
On the ground of DL, my lord. He was not holding effective driving license.
So how you will succeed in this appeal?
No, my lord, I have materials to substantiate. In fact, earlier, my lord.
That there is a driving license?
Yes, my lord.
Huh?
Yes, my lord. I'll place it on record.
No, you have to place it on record by this time. Otherwise, why would we grant
In
stay
this,
now?
what has happened, my lord? Earlier, there was an ex parte order. I approached this honorable court. I deposited 50% before this honorable court. In the meantime, my lord, there was parallelly we had made an application under for setting aside ex parte order also. That was allowed and it was reheard. But the material which I have placed is not considered by the tribunal on that ground.
What
my lord,
material you have placed?
My lord, I have placed, my lord, driving license copy we have produced,
How
but the
it is-
renewed one is not produced, which my lord, along with the application, will place it before.
In that case, then your owner is liable to pay. So what is the purpose of granting stay in this?
No, in fact, my lord,
I'll hear
50%.
it. I'll hear it on fourth.
May
Unnecessarily
make only one
let's-
submission, my lord,
Yes.
with my lord's kind leave. 50% deposit I have already made in the previous proceedings. That is before this honorable court, there is a deposit. So my lords may consider that because and it may be heard on fourth.
I will hear it. I will hear it and pass the orders itself on Thursday.
Please.
I mean on fourth,
Please.
not on fourth. List the matter on fifth.
Please, please.
Yes.
R4 is completed.
Hmm?
Notice.
Not necessary. Yes, 52.
Till number 52.
Claimant's appeal, my lords. I'm for the appellant, my lords. Liability is fixed on the R2, my lords.
On the?
Filing liability is fixed on the R2, my lords.
Insurance company.
Insurance company.
Which is
National Insurance, my lord.
National Insurance Company.
Filing memo for dispensation of notice to R1.
Memo is filed seeking dispensation notice to R1 dispensation at the risk of appellant. Mr. Ravish Benny is directed to take notice on behalf of the insurance company. Notice, then notice is complete. Admit, post of final hearing, call for the DCR.
53. Cell number 53.
Here for the appellant in
K.
this case,
Srinivas.
claimant's appellant seeking enhancement of compensation. Kindly notice to dispensation of notice to R1.
R1 dispense with?
SBI
R2
General Insurance Company. SBI General Insurance Company.
SBI.
General Insurance. P. Pradeep.
Pradeep is directed to take notice, admit post of final hearing, call for the TCR.
Cell number
Yes,
54. 54
Yes.
BC Shivanegowda.
Stay was granted.
54, this is
Connected to that, my lord,
connected to?
7, 8, a series case. Which
Yes, 54, same like petition is not maintainable. It's barred by limitation. Same. Next, 55.
Number 55.
I'm appealing for the appellant, my lordship. My lordship, here in this case, my lordship, claimant was not a pillion rider, my lordship. Because reason pillion petition himself was riding the scooter at the time of accident.
How much was granted?
3,02,378 rupees. my lordship.
Submitted that.
And there's a case of fraud and
in fact,
misrepresentation, my
In
lordship.
fact, the claimant is a rider of the motorcycle, not a pillion rider. Considering the same state, 50%, no permission withdrawal.
Cell
Yes.
number 56.
Much obliged, my lordship.
56. T. Nataraju. R2 Liberty.
Appearing for appellant, my lordship. Claimant's claim, my lord. Liability insurance company has been, gravity insurance company has been liable.
What is the insurance company's name?
Liberty
They are, claimant is claiming for enhancement of compensation.
Which is
Sorry.
the insurance company?
Liberty General Insurance.
Huh?
Liberty General Insurance.
Gravity.
R2.
RT. Liberty, man.
Only two advocates are there, Pradeep and Ravi Samprati. Ravi Samprati is directed to take notice on behalf of the insurance company. And what about R1?
R1 also, my lordship.
Huh? R1 is a necessary party or not? Ask him to file a memo.
Dispensation.
Memo is filed seeking dispensation of notice to R1. Dispense with at the risk of appellant. Admit post of final hearing. TCR.
Number 57.
57.
Cell number 57.
57, my lord, kindly issue notice to R1 and R2, my lord. R3 is a United Insurance Company, my lord.
Mr. K. Nagarajaya is directed to take notice on behalf of the insurance company. R1 and R2. Yes.
Cell number for judgment. Cell number 58.
So this you can call later. Complete the list.
Yes, ma'am. 59.
Yes.
59 also.
Yes, yes. That we will. That I will pass orders.
Cell
End
number
of the list.
60. Final hearing. Cell number 60.
Appear for appellant, mirror, challenging contributory negligence. Offending lorry has parked in the darkness.
All these final hearing matters on 5th. 60, 61, 62,
62.
62. Give other date on 12th. Then 63.
I am appellate, my lord. It is served
Then
unrepresented.
the manager SPA General Insurance 63. Mr. Pradeep is directed to take notice and the council shall serve the copy on him. This is on 5th. Then 64.
64.
Royal Sundaram. Who appears for Royal Sundaram?
B. Pradeep.
B. Pradeep is directed to take notice.
Records are required.
It is in final hearing stage. But how it is without records posted to final hearing?
Not yet
You can admit, call for the list this matter once the TCR is received. Yes, 64.
64.
64 is what it is. 65.
65.
Yes. Case of injury or death?
Injury.
List this matter on 5th of November.
Cell number
66.
It's also injury, man.
Same on 5th. 67.
67.
I am
Tata
appellate
H.
in this
appears.
case.
I appeal for
To appear, Mr.
SV
Mulkand is directed to take notice on behalf so and so the counsel for the appellant shall serve the copy. This also on 5th.
Cell number
68.
68.
68 for the respondent, my lord.
Case of death, my lord.
This on 4th.
Cell number 9.
69
For respond number 2, my lord.
What about this?
Case of injury, my lord.
5th. This is on 5th.
Please, my lord.
70.
70.
70.
Amputation of leg.
This is on 5th. Yes,
Cell number
71. 71 on 10th.
Cell number
72.
2.
Appellant in this case, my lord. TCR not received.
List this matter after TCR is received. 73.
73 death case, my lord, on 4th.
4th. Yes, 74. On 4th. On 4th.
74 Cholamandalam is served.
The first list on 4th. Yes, 74.
Cholamandalam is served. My any advocate for kindly be directed.
Cholamandalam, who appears?
Pradeep.
Pradeep is directed to take notice. Yes. Case of death or injury.
My lord, injury, my lord, injury. Records necessary.
It is on 10th. Yes.
Serial number 75.
It's a case of death, my lords.
This on 4th.
Serial number 76.
We'll call it now. End of the list. Take it. Call it at the end of the list. Yes.
77.
For the respondent, my lord. It's also on
Case of death or injury.
injury case.
10th.
Serial number 78.
For appointment, it's a case of injury, man. Kindly refer to Lok Adalat, my lord.
Both the parties submitted the matter may be referred to the Lok Adalat. Yes.
79.
My lord, appellant
Cholamandalam. Cholamandalam. Apart from Pradeep, who else are there for Cholamandalam?
Just Lingraj.
Huh?
Just Lingraj.
Mr. H.S. Lingraj is directed to take notice. This list is matter after TCR is received. Yes, 80.
Serial number 80.
What about this?
Sripad V. Shastri.
My lord, I am for appellant. My lord, it is a
Case of injury.
Injury, 10th. 81.
Case of injury.
81. This is also on 10th. 82.
82.
Case of injury.
80. This is also on 10th.
Serial number 83.
Injury case.
10th.
Serial number 24.
I am for appellant in 80.
Matter of,
For respondent.
it's a case of death or injury.
Injury.
Injury. List this matter after, for everything is asking for trial records. List this matter after the trial court records are received. Yes. Pradeep.
Case of injury, my lord.
This matter on 10th. 86.
26.
I'm sorry, but appellant, my lord, TCR is not received. TCR
Required.
yes. Yes, my lord.
We'll see. List the matter on 10th.
Serial number 87.
I am for appellant, my lord. Case of respondent.
Another cross appeal is there, my lord. Kindly connect the matter. Another cross
Another appeal is there. List along with so and so. It's a case of
Death, my lord.
death. This on 4th along with so and so.
Yes, yes, sir. Yes.
Number 28. Contract matters.
What about this?
Sandhya.
This matter also now I'll take up. Yes. Come to the next list.
List number 5. For order serial number 1.
Yes.
R3 is United India.
R3 is?
United India Insurance.
Mr. A. Ravi Shankar is directed to take notice on behalf of the third respondent insurance company. I number 1 of 24, 215 days, condoned on condition. Admit, oh, it's an ECA matter. Post this matter for final hearing, no admission. Yes, next, 2.
Number 2. Case I appear for respondents.
Notice
I appear for the appellant in this matter, my lord.
Case of
My lord,
death, my lord.
Yes,
But I for withdrawal of amount, my lord.
1 minute.
I am for appellant, my lord. R5 is third, unclaimed, my lord.
That's what I'm going to do.
Sorry, ma'am.
Turned as unclaimed, amounts to deemed service of notice. So with this, the notice
TCR is awaited, my lord.
Yes, Mr. Smart, admit final hearing.
My lord, I have filed IA for withdrawal of amount, my lord. Case of death, my lord.
Then list this matter on 4th.
My lord,
Yes.
Serial number 3. Shankraj K.
A week's time default order.
Serial number 4.
My lord, in serial number 4, my lord,
Notice to
actually,
my lord,
dispensed
no,
with
my lord.
one
Serial
of
number
24,
one
condoned
submission.
delay of 28 days, condoned.
Just one
My lord,
submission.
my lord,
Serial
one
number
submission,
4, my
one
lordship.
submission.
Respondent
R2,
number
my
2
lord.
liable to pay the compensation of the amount.
My lord, 1 minute, 1 minute, 1 minute. R2, actually, I already paid the process and notice is already gone. By mistake, I filed this dispensation memo. So, my lord,
Why are you filing all this by mistake?
Process is also paid and notice gone and it returned as served, my lord. Actually, I verified in the net.
Where from
It
you
is
get
only-
it? Look at it. Is it R2 served?
Yes, it is on served on postal Shara 21/6/2025.
It's submitted that R2 is already served. The memo to dismiss, seeking dispensation notice to R2 is withdrawn. Yes, what is the other matter?
My lordship, insurance company is exonerate, my lordship. Reason
Yes.
is fake policy they produced.
It's okay, no, I'm not going to hear all this. I number 1024 to condone the delay of 28 days, condone. Admit final hearing. Yes, 5.
Okay, for the appellant in this case, madam. One more connected matter, madam.
Number
7616.
1025 to condone the delay of 11 days, condone. List along with so and so.
Will be 10, madam.
Admit post for final hearing. Call for the DCR.
Number 6, Nagaraja K.
6 and
Who is
7,
the
my lord, I
Yes.
have my lord, I
A
will
week's
permit
time.
to take notice on the lowest court advocate, my lord.
A week's time. Before drop. Yes, 7.
8, 7
This also a week's time.
number 8, Satish Shetty.
Yes, a week's time. Default order.
Number 9,
Memo is filed seeking dispensation of notice to R1 dispense admit final hearing TCR.
number 10,
For the appellant, there was a little design furnishing the PF. So kindly it may be accepted.
What is the order earlier? There must be a default order. Then what is this acceptance?
Within 3 days it is to be furnished.
Default order.
Not default. Only within 3 days it is to be.
Let's see. See that, take that 10.
The no representation on appellant side. Call as per the office endorsement. Requests are not furnished for sending notice to respondent number 1, 2. Give fair opportunity. Time for 3 days is granted. Time for 3 days was granted. If not furnished, rupees 500 cost has to be paid. But I was not in station for some time. That time this happened. Kindly, my lord, it may be kindly be excused and it may kindly be accepted.
Now this order has to be reviewed by me.
But only thing, my lord, what the
No, you have not paid.
I'll
She
pay,
said
my lord.
in default, instead of doing all that, pay that 500.
I'll pay it, my lord. I'll pay it.
Yes, the on cost of petitioner submits that he'll pay the cost of at least 500. On such, the PF will be accepted. Yes.
Okay.
Next, 11.
number 11,
Notice to the respondent in 10. 11.
Dispensation memo.
Memo for whom?
Respondent number 1.
2.
I am for respondent number 2.
You are for 2.
Yes.
It's for 1.
I am
Memo is for seeking dispensation of notice. What is that? Some mute that where the sound is coming.
there, mute ಮಾಡಿದ್ರು ಮತ್ತೆ ಮತ್ತೆ disturbance ಬೇರೆ.
Memo is filed seeking dispensation of notice to R1. I number 1024 is filed to condone the delay of 91 days. Condone. Yes, next.
R3 United India.
Already appearing. B Pradeep for R2.
R2.
R3.
I think you have taken some other file.
8567 MFA.
8567.
Yes, next.
Cell number 12.
R3, my lord.
I number 1025 to condone the delay of not served. I number 1025 is filed to condone the delay of 368 days. Condoned on condition. Next 13.
Cell number 13.
Papers are served on the
Yes,
respondent.
they are served.
Sir. I number 1025 to condone the delay of 360 days, 6 days condoned. Admit post for final hearing. Call for the DCR.
14. Vojaraja.
Yes, it's time to.
A week's
Take-
time default order.
Cell number 15. Appear for the appellant. Needful done, my lord.
It is submitted that the needful is done. 16.
16.
For the
Admit post for final
respondents,
hearing.
my lords.
Number.
For the respondents, my lords, there is one cross appeal, my lords. Kindly have it connected with the MF.
Write it on the paper. List along with so and so. Admit post for final hearing. Call for the DCR.
17.
17. List after service of notice. Have you deposited the amount?
Because stay copy has been received by just 2 days back. I could not.
It is submitted that the stay order is received 2 days back. They'll be complying with the order. Yes, Nick.
Cell number 18, Girish B. Baldare.
Yes.
Please, in this case, I prefer for the respondent.
Uh,
In
I prefer
connected,
appellant in 18 point.
No, in 18 who appears?
R1
Furnishing
from-
of to issue R1. You appear for R1 in 18?
18.1, I prefer appellant.
No, that I understand.
connected in your
In 18, do you appear up for R1?
I have not yet received the appeal memo.
Look at it, who is R1 in,
R1
C is the,
person.
C is the respondent.
R1
madam.
is Kampegowda.
ನೀವು ನಿಮ್ದು ಅಪೀಲ್ ಇದೆಯಲ್ವಾ ತಗೊಳ್ಳಿ ನೀವು.
in 18.1 he is served. I think he is served in 18.
ICF, the Oriental Insurance Company is concerned, she may be directed to take
I may
notice.
be directed to.
No. 18, a week's time for paying process, service of notice on R1. That is 18. Then 18.1. Who is R4?
R4 is the owner of the vehicle.
No, notice required or not required?
Like, if
A
it is
week's
on
time,
liability.
finally.
19, Muralidhara and
Insurance company appeal, my lord. It is bar.
No, 19.
19.
No, Venkatesh Kamat. Yes, 5828 of 25.
4922 of 25 is 19.
Sorry, ma'am.
I have
Insurance
filed
company.
Huh?
company, insurance company.
Yes,
2 weeks.
Muralidhara and
Yeah, 2 weeks time may currently be granted.
a week's time, no 2 weeks. Week's time default order.
Cell number
Yes,
20.
20.
my lord.
I'm appealing for the respondent number
5
2,
days
my
delay,
lordship.
delay may be condoned, my lord.
I number 1 of 25 to condone the delay of 95
And
days.
today I filed the wakalat.
Condone, admit, final hearing, TCR.
Cell
Yes,
number 21, B. Pradeep.
Takes weeks time, my lord.
For complying the office objections, a week's time default order.
Cell number
Have
20.
deposited the amount.
We deposited, my
It is submitted that the memo, they've already filed the memo with regard to the deposit of amounts. Next memo is filed seeking dispensation of notice to R1 dispensed with. I have 1 of 25, 86 days condone on condition. Admit final hearing TCR.
Cell number 23.
List this matter after service of notice on R1 and R2. 24, this also R1 and R3.
Appealing
This
for
all-
appellant, my lord. In this case.
Which
the
case?
24 serial number. It is in bar by limitation, my lord. That is 5 days delay is there. Kindly stay may be granted, my lord. Serial number 24, my lord. Is company appeal, my lord.
Company appeal is also with a delay of 5 days.
Bar by limitation, my lord. That-
Your appeal.
Yes,
Your appeal is what by limitation.
no, my lord. That is MVC case, my lord.
Land council appearing for the appeal and submits that the appeal is filed. The claim petition that is filed is barred by limitation. Limitation questioning the insurance company before this court. Same stay of all further proceedings on the condition that they are not entitled to. No. Stay of all further proceedings on 50% of the no withdrawal permission. Notice to the respondents. 25.
Already notice is avoid stage, my lord.
List after service of notice.
25, my lord, R2, my lord, national insurance may be directed to take notice, my lord. So that, my lord.
National Insurance Company. Manjula and Tejasvi is directed to take notice on behalf of the respondent.
2, my lord.
2 and about 1.
R1 is service is awaited, my lord.
A list after service of notice to R1.
Number 26.
In this case, my lord, I have produced the certified copy connected matter, my lord. I have filed the application, this case, my lord, dispensation of notice, my lord. Already filed application, my lord.
In which appeal you have filed this?
My lord, 6823 of 2025, my lord, connected matter.
Where is that IA number?
I have filed the along with appeal, my lord.
Where is that IA to dispense with the filing of the certified copy?
No, this file kept in below.
Look at it, it must be along with that. It is numbered as?
My lord, connected 6823 of 2025, my lord.
IA is numbered as what? 1 or 2?
My lord, 6829 of 25. IA number 2 of 25, my lord.
IA number 2 of 25 is filed seeking dispensation of filing of the certified copy of the judgment. It is submitted that They have already filed a certified copy in the connected. I have one of 25. That it is filed in the connected, in another connected appeal, MFA number.
MFA number, my lord, 6823 up to 25.
Hence, the same is dispensed with, as already the type copy is filed. Yes. Notice, who are the respondents?
My lord,
R2 is Cholamandalam.
R2 Cholamandalam, my lord, R1 is kindly notice may be dispensed with, my lord. I filed it memo.
Mr. P.C. Shivanagowda is directed to take notice on behalf of the insurance company.
Not panel, advocate.
You're not
So,
there,
no.
Cholamandala. Who is?
B. Pradeep, my lord.
B. Pradeep is directed to. You are there. Mr. Muralidhar N is directed to take notice on behalf of the insurance company. Yes. Then what about the other respondent?
My lord, respond number 1, kindly direct notice may be dispensed with, my lord. I will file it memo.
File a memo. Memo is filed seeking dispensation of notice to R1, dispense with the risk of appellant. Admit, final hearing TCR. Next.
Number 27.
Yes, Mr. Dabali.
Delay of 156 days.
Notice to the respondent.
He has been served, my lord, sir.
Oh, it is served. I number 1024 to condone the delay of 156 days. Condone. Mr. Dabali to take notice on behalf of the respondent insurance company in MFA crop 50 of 2024.
I have received the copy.
Admit, post for final hearing, call for the TCR.
Kindly release the amount of participating deposit.
It's a case of death or injury.
Injuries.
We'll see. 10th of, list is marked on 10th of November.
Much.
Case 28. I number 1024 to condone the
10
delay of
days
10 days.
delay. 10 days
Condone, admit, final hearing, TCR 29.
Appellant, my lord.
328
National
days
Insurance.
delay, condone, on condition, admit, final hearing, TCR 30.
30.
So,
I am
Appellant,
representing C.R. Ravishankar. They have not served the copy of the appeal memo, my lord.
Yes, Mr. Girisha SN.
today itself I can serve through the email. Today itself I can serve.
Please serve.
Please,
I number
my lord.
125
Today
is
itself.
tried to condone the delay of 262 days. Condone. Admit, final hearing, TCR. S 31.
31.
31, my lord.
I number 1025 to condone the delay of 18 days. Condone. Admit, final hearing, TCR. Huh? SRTC. Oh. All the respondents are served.
Only one respondent, sole respondent.
Served. IA 1 of 25, condone the delay, condone. How much is the amount granted?
6,38,700.
Case of death or injury? There shall be stay of all further proceedings on the condition of 50%. They are entitled to withdraw 4 weeks. Admit, post of final hearing. Call for the DCR. 32.
Number 32. Amount is already.
Delay may be condoned.
Huh?
The month of July itself.
You have paid how much? I said 50% of the amount.
Yes.
Yes, 32. I number 1 of 25 to condone the delay of 27 days condone. In any of these matters, if any death case is there, you please mention.
Injury case.
Injury case of
Injury
injury.
case.
If it is there, I will take it up on Thursday.
Case of injury, kindly call for TCR, my lord, sir. Head injury is
Admit, post for
concerned.
final hearing, call for the DCR.
33.
33.
For appellant, my lord. Time is not filed the appeal.
I have received the copies, my lord. I have
Number
sent.
1 of
Not
25
yet received.
to
Father.
58 days on condoned on condition. Admit, final hearing.
Then number 34.
TCR 34.
34, my lord.
862 days condoned on condition.
Please.
Case of death or injury.
Injury, my lord.
Admit, final hearing, TCR 35.
35.
For the appellate in this case of injury, my lord, amputation. I am filing memo for a dispensation of R1.
A memo is
On
filed seeking
submission.
dispensation of notice.
And R2 already filed
They have
wakalat.
filed wakalat, my lord. 35 1 point.
Already Mr. Pradeep has filed appeal on behalf of the insurance.
Name not shown in the list.
I think they have wakalat not put up, my lord. Court directed.
The Mr. Pradeep is directed to take notice on behalf of the respondent. They have both in 35 and
We have
35.
already filed wakalat.
It is submitted. Mr. Pradeep has already filed wakalat. The registry is directed to put up the wakalat.
My lord,
Submission, my lord. In 31, already there is a stay and there is an order for.
But you were asking for stay.
Yes, my lord.
My lord,
I'm
on,
sorry, my lord.
17/9, my lord, the
17/9.
stay has been granted.
Yes,
I thought
31,
it's the-
whatever that remove and admit post of final hearing, call for the DCR.
Yes.
18 days.
My lord,
Yes.
35 already, we are already discussed, like to be settled, kindly we have it on fourth, my lord.
List this matter on 4th.
And the same connected matter.
Yes,
30
both the matters, both
Yes.
34, 35 and point 1 on 4th.
And,
36,
36.
dispensation.
Time for
I number
respondent
125. It is
Kindly
filed-
delete name HS Lingaraj name. may be
506 days in filing the
They may be
appeal,
not entertained.
condoned on condition. Delete the name of Mr. H.S. Lingaraj. As already Mr. Pradeep has filed wakalat. Yes,
For
Right.
admission matter, cell number 37.
37, maybe matter may be disposed more, next month, 4th, my lord. Next week, maybe, date maybe.
it's a case of death or injury.
Injury case.
Injury case, my lord. Both
List
injury.
on 10th.
Please, my lord.
Admit
Delay of
final
115
hearing.
days, my lord.
38.
Call for the DCR in 37.1, 115 days delay, condoned on condition. Yes, 38.
38.
38 is a owner appeal, my lord.
Owner.
Respondents claimants are served unrepresented. It is a owner appeal.
Let's see. Admit final hearing TCR 39.
39.
What about 39? Who are the respondents?
R2 is ICICI number.
Mr. A. N. Krishnaswamy is directed to take notice on behalf of the respondent. Who is the other respondent? Two.
R1.
R1 notice.
Cell number 40.
Records may be received.
Admit final hearing. Call for the DCR.
41.
41.
Paper appellant my lord. I served the copy my lord.
So it's a case of death or injury.
In case of death my lord.
List this matter on 4th. 42.
Cell number
I appear
42.
for the appellant, my lord. Only two issues involved, madam. Only amount, the case of death, madam. It is WC policy. My liability is only 12,000 rupees, but the tribunal has considered 15,000.
We'll consider this matter on Thursday.
Please.
On 4th.
Please.
List on 4th.
Cell number 43.
43.
Tantraj K.
Records may be necessary my lord.
Uh-huh.
Records may be necessary my lord. 43.
Admit post of final hearing. Call for the TCR.
Cell number 44.
They appeal for the respondent in the first case and appellant in the second case.
Case of
My lord, injury case and my lord, false implication.
admit post of final hearing. Call for the TCR. 45.
45. Prakash MH.
Yes, admit final hearing TCR. Now call those passover matters. What is this video for? Some matter is there.
That is Dharwad matter.
At what time it is mentioned?
He has not connected. I will be looking the PC.
Hmm.
That advocate on record is not connected. That is Withdrawal.
Let it come on 12th of November. Yes, call the passover matters.
Passover matters.
30.
List number 4, serial number 13.
Please.
Claimants appeal matter, only quantum. Honorable tribunal awarded
1 minute. Yes. No, this is not today's list, I think. Today's list. No, just now what I gave is,
List number 4, serial number 13. Mobile.
1 minute. This is 28th October list. What I gave you. Yes. Call the
List
list.
number 4, serial number 13.
But in this case,
Claimants appeal my lord. So case of injury.
1 minute. Yes, what do you say?
please, my lord, we have agreed to pay in additional 85,000 rupees.
85,000
That has been
global.
granted.
1 minute. Let's come to what is the amount granted?
1,50,000 is granted.
1 lakh?
Global.
50,000 is granted. He has produced the medical bills of rupees 87,965
Now, this additional amount is with interest or without interest?
without interest. Lump sum in addition.
What is that? 80,000.
85,000.
85.
5,000 globally.
Crest injury
Of
right
lower
lower limb with injury to foot.
My lord, that is only there is a-
Please come to the table.
Please, my lord.
Please come to the table.
No table, my lord, it's global.
Come to the synopsis. But this amount is itself globally.
See, the
Global amount of 1,50,000.
What has happened? Yes.
87th. Okay, please.
He has sustained such injury 87,000. Therefore, court has granted global compensation of 1,50,000. Now also he is not entitled.
Now, what are the grounds to enhance this 85,000?
Well, the pain and suffering 50,000 according to what I am calculating.
Amenities also.
Amenities 40,000. Loss of income for 3 months. It is 2021.
How many days he was in hospital?
29 days, my lord.
Please come.
Therefore,
That comes to use amount because he was dying 57,000 rupees. If you come to calculate in that way, my lord, it will come to a substantial amount. Therefore, I am not for it. Anyway.
Agreed with the award passed in ABC number 4525/2021, dated 9th February 2023, whereby the tribunal has granted an amount of rupees 50,000 global compensation with interest at 6% per annum from the date of petition till realization. The claimant is before this court seeking enhancement of the compensation. Then counsel appearing for the claimant submits that because of the injuries sustained by the claimant in the accident, he sustained permanent disability. He was in hospital for 29
days.
29 days. Further, he has spent huge amount towards the hospital charges. All these aspects were not considered by the court. The only ground on that, as the doctor was not examined, court has granted a global compensation. It is submitted that the amount needs to be enhanced. Next para, and counsel appearing for the insurance company submits that the court had rightly granted the compensation and there are no grounds to interfere. This court having heard so and so, peruse the material on record. Because of the injuries that are sustained, he has sustained a crush injury right lower limb with DE glowing injury, foot hypertension, and underwent operation. No doubt the doctor is not examined. According to the claimant, he took treatment as an inpatient from 16/7/2021 to 13/8/2021 and again from 18/10/2021. So it's all for a period of 29 days. And he has produced 46 medical bills for an amount of rupees 87,965. Considering all these aspects for the crush injury and for 29 days of hospitalization, and also considering the medical bills for an amount of rupees 54,357, this court deems it appropriate to grant another amount of rupees 85,000 without interest rates, in addition to what has been awarded by the tribunal.
Much.
Cell number 58. 58. Finally.
State, I appeal for the respondent claimants, my lord.
I think that's only the.
Madam, yes, Malad has already taken the view. But the once a notice is Malad sent.
Acknowledgement is not filed.
Yes, and Supreme Court has also concurred with that.
Now anything is with regard to the quantum.
Quantum, Malad, they
Have
wanted to.
I think I've already calculated
Yes,
the
Malad, I
quantum.
think some solution.
My lord, deceased was 17 years old.
1 minute. No.
He's not just a minor.
Look at it. There are two matters.
Next file is there. In this
No, in this I think I have made, look at it. You have to make the calculation. A list is marked on 4th in that first list.
Yes.
411.
Yes. What about
59?
other matter? It's already dictated.
It is already.
You that. Already order is also there, huh? You only taken. Oh, it's completed. Huh. Same. Yes, done. One more matter.
One more matter is there. Cell number
Somebody was saying
76.
about pay and recovery.
76.
Yes.
Challenging the order of pay and recovery. That
Order of granting
pay
or
and
not
recovery.
granting?
Order of pay and recovery granted.
Oh.
That's why I don't think that, and we have come to the conclusion, the understanding that he will be withdrawing the appeal. My appeal.
Yes.
Kindly
So
confirm
you're
this.
seeking, your file seeking enhancement. Serial number?
76.
Please come. Agreed with the award passed in MVC number 22259 of 2019, dated 1st June 2024, whereby the 24, both the insurance company as well as the claimants are before this court. The insurance company's appeal is MFA number 5072 of 2024 and the claimant's appeal is MFA number 6993 of 2024. The claim petition is filed seeking compensation of an amount of rupees, how much?
20 lakhs, madam.
20 lakhs for the injuries sustained by the claimant in the accident. The tribunal had granted the compensation
3,78,669.
as per the table given below at paragraph number 24. When it comes to the liability, the tribunal had fixed the liability. Where do you get it?
Your lordship could get it at
Para number. Para number 26, my lord. 25 and 26.
When it comes to the liability, the court
26,
has
my lord.
observed that there is no dispute that offending vehicle was insured with the second respondent and policy was in force as on the date of the accident. If the documents are perused more particularly, the charge sheet exhibit P5 shows that on investigation, IO has charge sheeted the rider of the offending vehicle in addition to the offense under section 279 and 338 of IPC, even for the offense under section 181 of the MV Act. The charge sheet produced by the claimant himself shows that the offending vehicle was ridden without driving license. Thereby, there is an admission that the driver was not having a valid driving license, and the court has held that the insurance company shall pay the amount and recover the same from the owner of the vehicle. In your case, the owner is served.
in my case, owner is served. In
That
his
is
case,
important. Your case is important.
in my case, it's served.
The land counsel appearing for the insurance company submits that it's a fundamental breach of terms and conditions of the policy. And when there is no driving license, question of pay and recover will not arise. Land counsel appearing for the respondent submits that. The claimant submits that. The court had considered the judgment in the light of the law laid down in Forensics case and Papu's case. Still, the insurance company is liable to pay the compensation. Then coming to the quantum, land counsel submits that for the injuries that are sustained by the claimant, the amount of compensation of 3,78,765 that is granted by the tribunal is on the lower side and same needs to be enhanced. Next para. And further counsels on either side peruse the material on record. The first submission of the insurance company with regard to the liability in the light of the settled law in Forensics case as well as Papu's case, even though there is no driving license, still the insurance company is liable to pay the compensation and shall recover the same from the owner of the vehicle. The tribunal had rightly applied the principle of pay and recover, and this court finds no reasons to interfere. Then coming to the appeal of the claimants, according to the as per the claimant, as per the wound certificate,
A compound fracture of type 3B and the right to first metatarsal comminuted fracture. Madam.
where do you get that?
No, your lordship could get it at
No, it's okay. The court had considered the injuries that are suffered by the petitioner under the head of pain and suffering, court has already granted an amount of rupees 50,000, and for the hospitalization towards incidental charges and also laid off period, and on all the counts the court had rightly considered and granted the compensation, and there are no grounds to interfere accordingly. The appeal filed by the insurance company, that is MFA number 5072 of 2024, and the appeal filed by the claimant MFA number 6993 of 2024 or dismissed. The amount in deposit shall be forthwith transferred. Yes, next.
Number 88. Appellant, my lords.
Yes, what is it? As per the calculation, no, it's pain and suffering 50,000, medical expenses 51,555, incidental expenses 10,000, loss of earning
28,500 for 3 months is granted.
then 1,19,700 is loss of future income.
Future income.
Loss of future income. 30,000 is amenities.
Yes.
Loss of amenities. What then 40,000 towards?
Towards future medical expense is already granted.
Future medical expense, which is granted by the court.
Which is granted by the tribunal, yes.
10,000 towards legal expense. So it's coming to 3,39,755. How much was granted by the tribunal?
3,19,755.
Where is the table?
Synopsis.
Oh, it is in
Synopsis.
That's why my synopsis is
Kannada.
I have
in
translated
English.
it is in English. Synopsis.
Synopsis perhaps contains all the details of the award.
So
and
basing
various-
on this, now I'll declare the order.
Yes.
Agreed with award passed in. MBC number. What is that number? 92 of 2017.
92 of 2017.
Dated 13 February 2024. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of how much?
My lords.
Seeking compensation for the injuries sustained by the claimant in the accident. The tribunal has granted the compensation as per the table given below. At the synopsis you
13 lakhs 19,000. Granted is 13 lakhs 19,755.
13 lakhs you sought for.
Sorry, 3 lakhs 19,000.
No, that I can understand. I'm asking how much you have claimed.
Your claim before the
Claimed
tribunal.
before the
No, anyhow, it's not necessary now. The counsel, the counsel appearing for the claimant submits that the tribunal on all the counts has not granted a reasonable compensation, and that needs to be enhanced. And counsel appearing for the respondent submits that the tribunal has granted a just and reasonable compensation, and no enhancement is called for. Considering how many are the injuries?
Both bones of the right leg.
Considering the two grievous injuries that are sustained, this court is granting an amount of rupees 50,000 towards pain and suffering. Medical expenses, court has already considered and granted an amount of rupees 51,555, and no enhancement is called for. The claimant is in hospital for
5 days. 5 days.
for 5 days, and the court has already granted 10,000. No enhancement is called for. Even in the head of loss of earning during the later period also, court had granted a reasonable on that, and loss of future earning, loss of amenities, future medical expenses, court had granted a reasonable amount, and no enhancement is called for. In the light of the law laid down in make laws so and so, legal expenses 10,000 altogether. The claimant is entitled for an amount of rupees 3,39,755. Accordingly, the appeal of the claimant is partly allowed, enhancing it from 3,19,755 to 3,39,755.
Delay of 141 days.
Delay of 141 days. Is it condoned or now it has to be?
To be condoned.
140?
1 days.
141 days condoned on condition. The same, sir. It's done. Now look at it. Tell me. Done.
Madam, list 4, serial number 54.